We are live. Hey, everybody. Fancy seeing you guys there again. It's been a busy day. Busy day. But we're here. So, welcome, everybody. Doing Weeknight Show tonight. Why not? Lot to talk about, lot to do. All kinds of fun stuff to get involved in. Um, um, what the heck is that? Why is this not working all right? Anyways, we're going to give people some time to get in here because I know this wasn't necessarily planned. But hey, you know what? When there's a spot to fill, why not fill it? Fill it with some good quality content overall. Um, so we've got some great things to talk about tonight. We got the Fani Willis text, the text that Terrence Bradley sent to Ashley Merchant, burning Fani Willis down, starting this whole disqualification thing into motion. Looking very, very good there. It is just beautiful. It is just beautiful, beautiful stuff. Um, so what what else we got tonight? Well, former President Trump is off the ballot in Illinois right now. Shocker. I know. Shocker they did it, but they did it, and we'll talk about that, what's going on with that. And then finally, and I guess it's what we're starting off tonight with. Today was the oral arguments for Monty v. Nick in the defamation lawsuit Monty has against Nick Rekieta. If you guys don't know that, Monty is suing Nick currently, alleging defamation. And today they had oral arguments over the um, issue of a conflict of laws, the choice of laws. So it's not really the merits of the case. It's about what rules are we going to use to decide the merits of this case and how to go forward. So we'll start with that tonight. But I want to see, got some people coming in. Jessica Lynn is a new member. Thanks, Jessica. Hope you're doing well. Thank you for the support. I know I'd be crying too. I'm so happy I'm crying too. Anyway, we gotta try to give people a couple minutes to get here. That's a shame, since that's what I always say. Um, somebody saw me over at Kino Casino, it sounds like. Yes, for 5 subs. Let's go. Bahrain says, do you just stream nonstop? How will you have enough time for hot tubs and happy ending massages? I mean, just today, I'm kind of, today I'm in that flow state. I hit, it's like Madonna says, you got to get into the groove, man. I'm in the groove right now, and we're working it. We're gonna keep working it. Tomorrow I've got stuff to do, but we'll do the Thursday night thing like normal. Just today's one of those days where you got it, so you keep hitting it till you run out of gas. There's no point in pulling up at any point. You just got to keep going. I need to pin the safe house again. It's down again. Okay, I'll take a look at it. I'll go fix that. So I want to say hello to everybody out there on tonight. We don't have the normal Thursday night menu of options tonight. We just got Rumble, Twitch, and YouTube, but we do have people over in locals. And I want to say hello to everybody over on locals, especially people hanging out in the safe house. That's the chat that's always up. And actually, it's showing pin for me. So, but I'll repin it just so you guys have it. Anyways, if you guys aren't aware what locals is, it's basically Patreon without all the crappy rules attached. And that's the nice part about it. They don't care what you say as long as you stay within their terms of service. They don't amorphously come back and penalize you, try to take your money, and get mad at you for saying things they don't like. So it's actually very nice. It's a very fair alternative to Patreon. And just like Patreon, you can put up posts. The neat thing is, if you are a member, and membership is free to join, you could put things up as well on the wall and in the community and talk with everybody that's there. But if you are a supporter, it's $3 a month. $10 gets you 2 months free. You get access to everything. And by everything else, I mean the live shows. We do at least one show every Wednesday, or live show every Monday at 8:30, and we go for a while. Last, past couple of weeks, and actually past couple of months, we've been doing big old shows, running out of time on the locals timer, timing it out at 3 hours, sometimes restarting it. Other nights we do a Thursday night show after we do the YouTube show starting at 9:30 here. Usually try to be over by 11:30 or just before midnight. We go over to locals and do an after show into Friday morning. Just hang out for a little bit, have fun, all that great stuff. So if you guys are interested, it's potentiallycriminal.locals.com. You can join there for free, like I said. You can also do promo code criminal if you're interested, but you're not sure. You can try Criminal 2024. You get 1 month free full access. There are no strings attached. If you don't like it, that's fine. If you do like it, well, obviously after that month's up, please join, become a supporter, and that way you get access to all the shows. Every once in a while, we'll do other stuff. I'll go live and we can hang out and talk. And yeah, it's a great time, and I highly recommend it. I mean, of course, I'd recommend it. It'd be weird if I didn't. All right, so I was going to give a couple more minutes, see who else is here tonight. Yeah, fill up them spots. Yep, all the way. Ah, let's see here. The number of judges willing to nullify democracy in America is frightening. Well, yes, but that is a symptom of where we are in our society. So hard times make strong men. So yes, access to everything means if you're passing through how you can sleep in my bed. Well, if I don't kill you before you get there, yes, then by all means you can sleep in the bed. Um, yes, it does not include spooning. Sorry, it does not. And um, hold on real quick, guys. 1 second. All right, guys. Sorry about that. I had to step away for 1 second. Okay, where is this not? Oh, we're clipping out already. Okay, I have to say something. I need to make a quick retraction. Stabby, I know you're out there. RoboCop 3 is a far better movie than RoboCop 2. They're both bad. They're not RoboCop 1. But I will not let you trip me up with that. RoboCop 3 is better than RoboCop 2. What I said earlier was a misstatement, and I'd like to correct that record. He knows who he is. And over at Rumble, I want to say Unanalio is first. And Tugging Tubin's over there. It's a weird time slot for Sean. Hey, got to get at it if you want it. That's how it goes. So we're going at it. I wasn't able to see the Rumble chat before when Ethan Ralph was on. No, I couldn't. Rumble chat was all like, it was all fucky wucky to me. So I'm gonna have to take a look at it later, see if I can watch it, or there's a way to see the Rumble chat because I wanted to see it. I was curious what your guys' reaction was over there. If you guys weren't aware, earlier today we did the live stream of Monty and Rekieta, Monty and Nick. We watched it. We talked about it. Josh Moon came by to say hello. And then Ethan Ralph came by to say hello. Apparently, Daddy Jim was in the chat floating around. I'm not sure. I'm not too sure how it is. They say he's always there, but is he? You never know. I mean, he's always there because he's kind of the sector. I mean, he's the embodiment of the sector, so he's everywhere. And I'm not necessarily part of the sector, but I'm kind of touching it. I'm kind of like on the edges. So Jim is everywhere. I mean, if he really was there, cool. But we had the the esteemed Ethan Ralph on, the great senator from the city of Merida. And yeah, we did great. It was a fun time. Fun time had by all. Karen says, I missed the live stream. Well, don't worry about that because we are going to start with the actual oral arguments. We're going to watch those and go through them. The neat thing is, I will just shout out to Alyssa. She synced up the audio and the video and put it together, which is really nice because we can do it. We can do it. So, and it's not too long. And really, guys, as far as the show goes, we're not going to go super, super long tonight. I don't, unless you guys, not going to pull a dark side Phil here. I'm going to pull an Ethan Ralph. Got to meet the goal, chat. We got to meet the goal if you want me to go all night. But otherwise, we are going to have some fun tonight. We're going to talk about this stuff and look for everything. It's 10 minutes. We got 156 people here. Let's fucking go. And we got some people over in Rumble, so let's just do this. I'm an orbiter. I'll take that. I'm in the orbit. I'm like Haley's Comet. I push around once in a while. So here we go. Mike says I rub it like a little kid at an art museum. Hey, that's how we got to do it. That's how we got to do it. So let's go. All right. So Alyssa clipped this. Now, what happened? So obviously, you guys know the story. Monty is suing Nick Rekieta. All right, cool. Nick filed a motion to dismiss. Monty sued Nick using Minnesota law because his argument is it doesn't matter where I live. Nick said a harmful thing to my reputation and damaged me personally in Minnesota. So I have damage in Minnesota. That's where the tort happened. I'm suing there. That's the cause of action. That is an acceptable answer, an acceptable way of doing things. It's not the preferred way of doing things. Typically, when you suffer a tort claim, you typically file it either where you live, because that's probably where it happened to you, or the place where it happened. So, for example, if Nick and Monty got into a car accident in Florida, but Nick is from Minnesota and Monty is from Colorado, they would file it in Florida. Monty could file it in Florida because that's where it happened. That doesn't make a whole lot of sense, but they could do it that way. In this situation, it's just two of them in two states. Now, I know Monty has already said he didn't live in Colorado at the time. He was living in Illinois. And earlier today, Monty actually did introduce an interesting fact. According to him, he had filed suit in Colorado on a previous case. And he was told by the courts then when he did it, I think he was representing himself at that point, he should have filed it where the guy lived and dismiss his case. Now, it sounds like Monty took that to heart, so that's why he went ahead and sued Nick in Minnesota. Like I said, it's not wrong. It's just not what's normally done. So it doesn't make it wrong. It's just like a multiple choice test. Which is the more correct answer? They both might be correct, but one's more correct than the other. So it's not an issue of right or wrong. It's just which rules apply. So Nick has argued that Colorado's law should apply because Nick is claiming Monty lived in Colorado at the time he filed the suit. Now, why is Colorado important? They have anti-SLAPP. And a SLAPP lawsuit is a strategic lawsuit against public participation. So that is a lawsuit you use of any type for any type of action to silence someone from talking further. So a great example of that, besides Nick and Monty, would be the Afro Man situation. What happened to the rapper Afro Man? Down in Southern Ohio, the police raided his house in a very questionable manner, and he had it all on film. So he started making songs and making fun of them. Well, they got butthurt and they filed lawsuits against him to shut him up. Well, that's considered a strategic lawsuit against public participation. It's meant to chill his speech. Now, why does all this matter? Well, there are anti-SLAPP statutes in some states, and those states allow you to challenge the lawsuit before you get to discovery, because discovery is expensive. It's burdensome, and it can be invasive and embarrassing and problematic. Well, if you can defeat the lawsuit at the preliminary stage, that saves you time, money, and problems. So there are states that have anti-SLAPP statutes where, for the most part, absent certain facts and situations and conditions, your lawsuit will get dismissed on grounds that it violates the anti-SLAPP statute. Now, Colorado's is somewhat okay. It's a pretty robust one, but some states have more robust ones. For example, Texas. The whole situation with Vic Mignogna. Texas had an insane anti-SLAPP statute. Well, Texas modified theirs after the whole Vic Mignogna thing because it led to undesirable outcomes and things that weren't intended. The other thing with anti-SLAPP statutes typically is also if you lose an anti-SLAPP, if you file a lawsuit and you get struck down by anti-SLAPP, typically you have to pay attorney's fees for that. That's not a good thing. So, and that said, if you file and you do take something anti-SLAPP and the other side wins, the filing the lawsuit wins, well, you owe them attorney's fees. So there's fee shifting provisions in these statutes. So there's a lot at stake. Now, Minnesota does not have anti-SLAPP. So it's beneficial to Monty, not to Nick. Whereas Colorado's beneficial to Nick, but not to Monty. So you can see there's a preference on which law applies. Now, even though this is state court, some of you are thinking, well, how can you apply law from one state, Colorado law in Minnesota? This happens all the time. Even though typically you're in federal court, that becomes the issue. In state courts, you can do this. And this is very common in contracts that parties will agree that the law of a certain state applies. That might not be the state either party's in currently or one of the parties is in currently, and then they may end up in a third party state. So they could agree Rhode Island law applies and governs the contract, but the lawsuit happens in Ohio, or it happens in Missouri, or it happens in Texas. That does happen. Those are kind of screwy situations, but they do happen from time to time. And this is kind of one of those situations where Nick wants the law from one state to be used in his state. And then obviously Monty wants Minnesota law to apply in Minnesota. The trial court dismissed Nick's motion to dismiss and said it was overruled, denied it, said it didn't matter. So Nick filed what's called an interlocutory appeal. So it said, Judge, timeout, I want to challenge this. So it went to the Court of Appeals in Minnesota, and that's where they are right now. And today, Monty's attorneys up, and then Nick's attorneys went up, and they argued everything that happened. And I apologize. Nick's attorney, Mark Randazzo, went first. Monty's attorney went second, and then because Mark Randazzo and Nick are bringing the appeal, they have the right of rebuttal, so they get to end it. It's about 40 minutes total, but we're going to go through it, and we'll talk about it as they go. So here we go. I know there's a lot of talking, but I want to make sure you guys understand where we are with this in case you weren't here this morning. So, hold on. We got to boost the sound on this because it's not the loudest. So, Nick is not going to, if you guys are coming to see Nick, he's not in here. If you guys are looking to see Monty, he's not here. The Court of Appeals is look at this. It's a super small courtroom. It's not meant for spectators, generally speaking. Your attorneys come in and do their work. In criminal cases, same thing. Your attorneys coming in to do work. That's it.
This morning is Quest versus Rekieta, and please feel free to correct my pronunciation of the last names.
By the way, Quest is Steve Quest. That is Montegraff's name. I know also he goes at one point like Roy Warren Marshall, but he's Steve Quest in the filings. And Nick Rekieta is Nick Rekieta.
Case number for that case is A23-1337, if counsel for that case would approach.
If I could ask for an indulgence.
Dave Schneider.
Pleasure.
How are you doing today?
Oh, that would be fine.
Would be undignified normally.
Dave Schneider.
Pleasure.
How are you doing today?
Oh, that would be fine.
Would be undignified normally.
Oh, damn it. I muted that, didn't I? Son of a bitch. Oh, God almighty. So, anyway, real quick, guys, if you didn't hear.
How are you doing?
for an indulgence.
Dave Schneider.
So that's Dave Schneider, Nick's best friend, the named partner of the Schneider Metzen law firm out in Spicer, Minnesota. You know, your go-to if you have any sort of civil tort injury out that way. Runs a law firm with another partner and an associate. So if you guys have needs out there, that's who I'd recommend you go to if you're out that way in Minnesota. This guy right here sitting at the table is their appellate attorney they hired. And then this here is Mark Randazza, Nick's guy.
How are you doing today?
That would be fine.
Would be undignified normally. Thank you.
Good morning, council.
Morning.
As I'm sure you both know, you'll each be given 15 minutes for your argument this morning, and appellant, you'll be given 5 minutes for rebuttal. If you could both, before beginning your argument, identify yourselves and your client for the audio record. And the bench is adjustable, so feel free to take your time adjusting the bench prior to beginning your argument. So with that, counsel for appellant, if you're ready.
Thank you. I am Mark John Randazza. I'm here for the appellant, Nick Rekieta. I am with my co-counsel, Matt Kazaya. And that may it please the court. This case is about an internet celebrity beef ongoing for about 5 years.
That's one way of putting it.
But this appeal is about predictability, consistency, and discouraging forum shopping. After years of back and forth nastiness by two men who proclaimed themselves to be jokesters, this very unserious beef has become a libel tourism trip to the Minnesota courts. To embark on this trip, Mr. Quest, or as he's also known, Montagraph, or October Rains, or any number of aliases, picked through the party's juvenile back and forth banter and found statements that were void of necessary context might seem a bit out there. But in a defamation case, context is everything. Now, the law requires that a trial judge view the existing evidence at summary judgment through the substantive evidentiary burden. Now, today, this did not happen before, and today you have the task of deciding if Minnesota wants to depart from the nationally preferred framework to become a libel tourism destination. In a multi-state defamation case, the presumptive choice of law in most states is where the plaintiff's reputation is, because that's where the plaintiff's reputation is based, is a creature of that plaintiff's state law. The lower court incorrectly presumed that Minnesota law applied, but that was flawed from the start. It began with a flawed observation that if she applied Colorado law, the Colorado anti-SLAPP law is much more powerful than it really is. She presumed, I believe, that it would have foreclosed the claims altogether, when it really would have just changed that prism through which she has to look at the facts and the substantive effect of them on the law. Because the lower court said that the Colorado law gives immunity to Rekieta statements. It may, but it's far more complicated than that. What it really does is it requires that he show a degree of minimal merit. It's perhaps a very anemic qualified immunity, not a blanket immunity. Now, the factors that we should look at, there's really kind of a split in Minnesota, it seems. Some cases look at this Milkovich test. Others look at the restatement 150. I believe that you get to the same result no matter which one you look at, and I would suggest that this court adopt restatement 150.
Are you aware of any Minnesota case law that used the most significant relationship approach to resolve a choice of law issue in a tort case like this one?
Like this one, no. because this one is
Or any
frankly,
tort case outside. I mean, it seems like you rely heavily on criminal cases.
I believe we briefed one, Your Honor, but I'd be lying to you if I said I had that citation at my fingertips right now. But if we look at it through Milkovich anyway, I think we get to the same place. First, we have to look at predictability. Well, applying Colorado law is going to serve the principle of predictability. The principle here is the case should be the same no matter where it is filed, and that's to avoid forum shopping. That's what your NODAC case says. So if the case would be different if you file it here or there, well, then we have this factor in our favor. The nationally approved approach, the one Quest asks you to abandon, flies in the face of NODAC's instruction and creates a perverse incentive to any resident of the 35 anti-SLAPP states to come and file here.
But doesn't the first factor rely on the expectation of which law would apply? And in this case, why would it have been expected that Colorado law would apply? I mean, you started out your remarks by pointing out concern about injury to reputation in Colorado, but you also said that both of these individuals are internet celebrities. So
Yes.
Isn't their notoriety really everywhere?
Well, if their notoriety is certainly everywhere. But if Mr. Rekieta were to go to another state to have his reputation taken care of, it would still be a matter of state law. It's essentially, if you have a building in another state, you're going to expect it's built to that state's building codes, not that it would be a different building code no matter who visits it. That's probably the closest analogy I could come up with. But your reputation management law, your corpus of that.
That's actually not a bad argument, a bad way to phrase it, that it's the state law that governs it, not the state law of whoever comes into your building. I think that it makes sense to me, and I like that. It's really hard to come up with a very appropriate description, but I think that's pretty good by Randazza.
Body of law is created by your home state. Remember, Colorado has a different standard for defamation than Minnesota does. Not a very big difference, but enough of a difference that it could change the outcome.
Does it though? In a situation like this, when we're talking about what Minnesota considers to be defamation per se, but really an allegation, or at least as you said, an insult that Mr. Quest is a pedophile. Isn't it true that under Colorado law, that's a matter that would be considered a matter of public concern that would lead to, under at least the case law applying the anti-SLAPP statute, this heightened pretrial burden of proving by clear and convincing evidence, which was exactly the concern that led the Minnesota Supreme Court to strike down Minnesota's anti-SLAPP statute?
I could not have written a better question to illustrate the point. That's excellent. It's no. The Colorado anti-SLAPP law does not have a clear and convincing evidence standard in it. It is simply
It's not in the statute, but the cases apply it even as recently as 2023. Colorado cases do.
So do your cases. All cases, in fact, since Anderson versus Liberty Lobby, when you're dealing, and that's a Supreme Court case, when you're dealing with a public figure in every state to be consistent with the First Amendment, you must show that a reasonable jury could come to the conclusion that you had superseded that clear and convincing evidence of actual malice standard. So yes, it can be somewhat confusing because there were the old Washington statute and the old Minnesota statute required the plaintiff to show clear and convincing evidence of defamation. That's different than saying a reasonable juror could overcome the Bose standard, the Anderson versus Liberty Lobby standard laid down by the Supreme Court, that a public figure plaintiff must show by clear and convincing evidence that the actual malice defense has been overcome.
Counsel, I want to follow up on that. So, and you raised the Washington statute, which, like Minnesota, anti-SLAPP statute, had been struck down. But unlike Minnesota, Washington then revised their anti-SLAPP statute and appears to incorporate at least 3 different ways that it can be knocked out. In other words, summary judgment, motion to dismiss, failure to plead sufficient facts, which are commonly used as, if not rule-based, statutory-based method, accepted methods to dismiss cases.
Yes, Your Honor.
If I understand your argument correctly, are you arguing that the Colorado statute, unlike the Minnesota one, utilizes, based on case law interpreting the statute, a summary judgment standard, which would, at least on its face, would appear to be an appropriate standard that would not take away the fact finding from a jury?
Correct. LSS versus SAP 2022 Court of Appeals 123 from Colorado says very clearly, the court does not weigh evidence, nor does it resolve conflicting factual claims when looking at the anti-SLAPP law. But it's not just the anti-SLAPP law that we have to look at. We also have to look at the full underlying body of Colorado case law. I believe that you can have statements in Minnesota that, frankly, Minnesota might be too civilized to tolerate, that would be tolerated in Colorado. In Booker versus Roberts, for example, at the Colorado Supreme Court, it's 198 Colorado 1. And as far back, that's from 1979. It's even much older than the anti-SLAPP law. Approves of abusive statements that are outbursts of anger. And I'm not going to repeat what they were there unless you order me to, but they would certainly be indelicate anyway.
They don't want Mark saying all the words. But no, and this is the issue, guys. This may seem very dry and boring to you, but this is what conflicts of laws is about. The choice of law. You know, that's the issue here. And yes, this is a lot of back and forth between these judges and Mark, and they're talking about this case and that case, and you know, Mark is talking about Minnesota cases, then also running back to Colorado, but then he threw in Supreme Court cases. You know, there's a lot going on here, but this is the heart of that argument.
And might be defamatory in Minnesota, but in Colorado, the Colorado legislature and the Colorado courts have looked at their citizens and said, we're going to balance your reputational management rights and your First Amendment rights differently than Minnesota does. Now, that's certainly Minnesota's right to do that. But what you don't want to create here today, I don't think, is a Coloradan seeking an unfair advantage in a defamation case by coming to Minnesota to get a result he could not have achieved at home. He should at least have, theoretically, if we have cloned the two judges and put them on two different benches in two different states, that you'd have the same outcome. Colorado law is the law that should govern that decision-making process. So not just do we apply the anti-SLAPP law, but even if, let's say that you remand it with the lower court's instruction to apply the Colorado anti-SLAPP law and apply Colorado law, she could apply it. She might. I can't predict exactly what she'll do. I'm confident she would find that it eliminates this case, but she might say it doesn't fit the anti-SLAPP law. However, consistent
Hasn't the district court already ruled that if this is a summary judgment standard, that summary judgment isn't appropriate at this stage because discovery hasn't commenced? And how does that decision interplay with the application of the Colorado statute?
Again, you guys must be spying on my outline, because this nails the issue right there. That what she was doing was applying Minnesota law to that. So yes, under Minnesota law, her decision may have been correct. I frankly, I don't think it is, but let's presume that it is, because her summary
Because
judgment.
Minnesota's procedural rules would apply. You don't disagree that the Minnesota procedural rules would apply to this proceeding?
Oh, they definitely would apply. So that's why I don't think that the Colorado anti-SLAPP laws, stay on discovery, for example, would apply in Minnesota court. Only the substantive rights come into Minnesota.
And
that's a big distinction here, because they're arguing over what laws apply, but they also, that said though, Randazza and Nick are agreeing, Minnesota's rules of civil procedure, how a case is governed, how discovery proceeds, that controls. That's a separate matter. So for example, the filing periods, the filing deadlines, if you file a complaint, they have 28 days to respond. And within that 28 days, they also have the right to amend. And if they want to amend after that, they need leave of court. And the other parties can amend All those different rules you've ever heard about in civil cases, those are governed by rules of civil procedure. Minnesota has their own, Colorado has their own. They're generally fairly the same for the most part, but they're different enough you have to know what you're doing. Randaz is saying that in Colorado, this anti-SLAPP motion would put a pause on everything. In Minnesota, it sounds like even if the court were to look into it, discovery still might go forward, but then Nick could quash it later. And Randaz is acknowledging that's the way that would go.
So responded with,
Um,
respondent would still be entitled, even if we agree with you, respondent may still be entitled under Minnesota's procedural rules to have additional discovery prior to a hearing on this motion. If it's true that the anti-SLAPP is applying a summary judgment standard, and in Minnesota, we say you're entitled to discovery prior to summary judgment.
If that discovery would change something, yes. But when we're looking at simply matters of law, it's a matter of law whether someone's a public figure. And I think we've established that. It's also a matter of law if, for example, the level of rhetorical hyperbole here would be tolerated under Colorado law. Her decision was flawed in looking at summary judgment because she failed to look through the prism of Colorado substantive law. Colorado substantive law gives a wider berth to speech than Minnesota substantive law in this circumstance.
Counsel, I want to follow up with on Judge Larson's excellent question, because what would happen if Colorado substantive law applied? In other words, even if the special motion to dismiss under anti-SLAPP law had been presented, wouldn't when there be the possibility to argue, wait a minute, that's premature, because if that is indeed Colorado's equivalent of a summary judgment standard of review that applies, we need to have discovery first before a decision is made. In other words, would Colorado's substantive process, well, procedural and substantive process, be the same as Minnesota's?
The procedure would be different. In Colorado, there's an automatic stay on discovery, which I have not argued would apply here. Here, you would have a presumptive right to that discovery, but upon facing a summary judgment motion, let's say I'm arguing that he's a public figure here, and here it all is, there's no discovery that's going to change that. The only discovery below that they said that they needed was discovery on Mr. Quest's medical records, which I presume he has. So what, if they need that, why did they not get that before? You know, you frequently find, this is pretty much all I do. And I always find when.
And I like I said, guys, because I mentioned this before, I mentioned earlier, because I'm listed in that, I don't feel like it's proper for me to comment on the merits of the case for Nick or Monty. Yes, Randazza brings up a great point. Yeah, there's discovery. Sure, we can find. We'll take time to go through discovery. The only discovery that's really out there, the only fact in dispute at this point is Monty's level of damages. Now, yes, with a defamation per se, damages are presumed, and that's fine. Even then, part of what Monty would... So, how to explain it to Josh? If you get run over by a car and you lose your leg, completely cut off, obviously you suffered damages, right? Nobody's going to disagree with that. But the argument's going to be, what damages are you? Because everybody knows you suffered a damage. Your leg is gone. You suffered damage. You suffered harm. Okay. How much are you entitled to is a different story. So that's a lot of times what becomes an issue in civil cases. There's damages. Everybody agrees there's a damage, there's a harm. Nothing you can do about that. I get run over by a drunk driver and lose my legs. Well, okay, it'd probably be a really big car to run me over and take my legs off. Let's say they got like big mud tires on or something, and I lose my legs. We're going to have to we'd have to have then a trial on damages. That I would have to then prove how much damage, how much harm have I suffered. So yes, there might be a presumption that there is damage, there is harm. You have to quantify it still. So even though Monty can come in and say, "Well, I've been harmed," okay, cool. How much harm have you suffered? He then has to provide that and quantify it, because otherwise the jury has no way to. If the jury were to find for him, they'd have no way to award for him because they don't know how much he suffered. So that's why this becomes an issue of what has Monty done suffered damage wise, and that's the only part that's left. So I do think, and I'll tell you guys what I think is going to happen when we get done with Randazza before we start Monty's attorney.
Someone's trying to end this case early, the answer is we need discovery. And then the question is, well, what do you need? And the answer is we need discovery. It's just a circular argument. But, you know, in federal court, for example, Rule 56D,
Hey, chat, I don't know what the hell happened there. I didn't touch anything. Ooh. YouTube did not like I don't know what happened there. I think we got attacked. That was weird. So we'll be back. We're gonna get that back. Yeah, that what the fuck was that all about? Anyway, we're gonna get back to this. Well, if I get shut down again,
no discovery is going to change that.
so that was weird. So let's just go back. We'll go back a minute or two, and we'll figure. God, that was weird. I'm just sitting here and it just died. They sense my power, chat. They know I'm getting too powerful. They're killing me in the crib.
But upon facing a summary judgment motion, let's say I'm arguing that he's a public figure here, and here it all is. There's no discovery that's going to change that. The only discovery below that they said that they needed was discovery on Mr. Quest's medical records, which I presume he has. So what if they need that? Why did they not get that before? You know, you frequently find. I mean, this is pretty much all I do. And I always find when someone's trying to end this case early, the answer is we need discovery. And then the question is, well, what do you need? And the answer is we need discovery. It's just a circular argument. But, you know, in federal court, for example, Rule 56D, you have to at least say what it is you need. And that is this, I think that's the standard. I'm sorry, I'm just going to plead ignorance on Minnesota procedure here. I'm not from here, but you know, every state that I've been in, there has been a 56D equivalent where you don't just say, I need discovery in some great universe of that concept. You say what you need. Well, what is it you need to show that this isn't rhetorical hyperbole under Colorado law?
You can't go on a fishing expedition.
I don't think you can. No, I think you have to have very targeted and specific discovery when you're faced with a summary judgment motion, whether it's under the auspices of the anti-SLAPP law or simply under summary judgment. Thank you, Your Honors.
Thank you, counsel. You'll have 5 minutes for rebuttal. Counsel for.
Okay, yeah, that's funny. Yeah, my computer has a. Hold on, let me check it out. Yeah, it feels cold, but yeah, maybe it's got 107 degrees centigrade fever. That would be really, really bad. That'd be grad. Yes. Now, to be fair, guys, I know some of you are saying like Randazza's thing there about I don't know how you guys do it. That's not. He's being honest. I don't know how you guys do it, but more than likely, it's similar to the Rule 56 of the Federal Rules of Civil Procedure, and I guarantee you, we'll look it up right now. We'll do some lawyer stuff. Minnesota Rules of Civil Procedure. Okay, Minnesota Rules of Civil Procedure. Here we go. All right, so here's the Minnesota Rules of Civil Procedure. These govern how you handle stuff. Let's see if we can do this in PDF form. This will be a little easier to read. Okay. All right, chat, here we go. Rule 4, no, we need Rule 56. Let's see what they call it. Yeah, see, isn't that kind of funny? It's like, wow. It's like everybody's kind of standardized on a set situation. So, like Rule 56, summary judgment. Funny seeing you here. Now, talks about like motion for a summary judgment or partial judgment. It talks about the time to file it, the procedures, when facts are unavailable to the non-movement. So we need this one right here. When facts are unavailable to the non-movement. So this case, Monty's the non-movement. Let's see what that says. 56.4. It's just table of contents. All right. We need to go back. Went too far, chat. We got to go back. All right. Rule 56.4. 0.04, I'm sorry. All right. When facts aren't available to the non-movement. Okay. If a non-movement, which is Monty, shows by an affidavit, which he can show, for specified reasons, it cannot present facts essential to justify its opposition. The court may defer considering the motion to deny it, allow time to obtain affidavits or to take discovery, or issue an appropriate order. Basically, what Mark Randazza just said. Well, the court can keep it open, but I don't know why they need to. It's absent Monty showing why they need it, the court won't keep it open. So, I mean, he literally nailed it. But if you're not sure, you don't want to say it, because if you're not 100% right, they're going to think you're a blithering idiot. So Randazza handled that the right way. I would argue he did that right. So I know anime sucks, Copen's need, which I'll agree with you on some anime. That wasn't a bad answer. I think that was an acceptable answer. A couple other things some of you guys have said, though. According to the Minnesota Rules of Procedure, you have to read these in Jesse Ventura voice. I cannot do a Jesse Ventura voice. All I can do is the thermite paint. So, because that's what they coated the World Trade Center beams in. Thermite paint all over it. Thermite paint. But you guys, there were some questions, though. And Unknown Hero for $2 said, "Oh, I'm going to come." Well, don't come. Don't come. Aaron says, "Is it weird that I find this interesting?" Not really. This is some of the more interesting parts of like doing lawyer stuff. And Potatoes After Dark says, "Choice of rule is a complex beast." Yes, it is. And Pepsi Man, you're this whole oh my gosh, Josh, Judge, by golly, you're so smart. Oh, believe it or not, judges like to be flattered. Okay, judges love having their ego stroked. I will tell you that every day of the week. Judges love to be told, "Judge, you're like a million steps ahead of me, but I'm running down that path. I need, Judge, I need to catch up to you." They love that. They love you. They love being BS. Judges love having smoke just crawling up their ass. They love it when you blow smoke. I can tell you that is entirely that's normal. And also it's why not flatter? It can't hurt you. And I will say, Randazza was already anticipating those questions. That's another part of appellate practice, is knowing what's going to happen and how you're going to prepare for it. So, like I said, he's doing pretty good. And Sleazy, you want to know what my odds are? We'll talk about that in a second. So the guy next is up for Monty. This is the appellate attorney they hired. And there's nothing wrong with that, because Schneider probably realizes I don't do appellate stuff. So he let another guy do it, which isn't a big deal if you aren't normally involved in that. So here we go.
Or respondent. Feel free to adjust the podium.
Is there a trick to raising it?
There's a
Button doesn't seem to be doing anything. Oh, there we go. Good morning, Your Honors. May it please the court, my name is Chris.
Also, you have to do that. May it please the court. You have that's like one of the few magic words when you're doing attorney shit. You actually have to say, like, Good morning, Your Honor. May it please the court? Like, you have to do that. That is the formal. If you don't do that, you're looked at as like, do you know what the hell you're doing? That's some of the things I don't like as an attorney. You have to do sometimes the magic. You have to say magic words. That's one of the few times you have to say the magic words.
Christopher Bowman from the Office of Madigan, Dull and Harlan, and I'm here today on behalf of Respondent Steve Quest. The sole issue before the court today is relatively straightforward. Did the district court err by applying Minnesota law to
Oh, good logic, Raid. Hey, guys, how you doing? We are watching the oral arguments of Montegraph versus Nick. And Nick's attorney just went. Now Montegraph's attorney is about to start. So here we go.
this dispute rather than subjecting this claim to Colorado's anti-SLAPP statute? Minnesota's choice of law framework is based on consideration of what all today call the 5 Jepson factors: predictability of the results, maintenance of interstate order, simplification of judicial task, advancement of the forum's governmental interests, and if still undetermined, application of the better rule of law. In this case,
Do you think Minnesota law is clear that that's the correct test that we apply to the application of whether this substantive law should apply in Minnesota? Do you think the Supreme Court has clearly said that that's the correct test?
I do think
I read I think it's Castillo Alvarez case. I don't know if the Supreme Court has clearly stated anything in terms of what our precise choice of law test is, but
I don't know. As I stand here today, I'm not aware of any Supreme Court case law that directly articulates that in a tort context. This court has said that in the Lohman versus East Grand Forks case. I recognize review was granted, but subsequently vacated by that. So I think it is established that the 5 Jepson factor test is the controlling framework here.
under our court's precedent.
Correct. And in this case, not necessarily in every case, but in this case, that 4th factor, protecting Minnesota's governmental interests, Minnesota as the forum state, so overwhelmingly supports application of Minnesota law as to be, in essence, determinative, compelling affirmance of the district court's decision.
Counsel, I have a concern about that. You argue vociferously in your briefing that is outcome determinative, but aren't we supposed to look at the 5 factors and the 4 factors in particular and have an analysis of each one versus just saying, oh, this one factor controls the whole analysis, so you don't even need to look at the other ones. This one is the nail in the coffin.
I want to make sure I'm understanding where you said the 4 in particular. Do you mean everything other than application of the better rule of law?
Correct. 1 through 4.
Yes. I think it's a balancing of the at least those 1 through 4 factors. And here, factor 4 weighs so overwhelmingly, and I would submit that the factors 1 through 3 either similarly support Minnesota law or, for the simplification of judicial task, is probably neutral. But I don't believe that any of them support application of Colorado's law. So, if you look at 1 through 3 being either neutral or leaning application of Minnesota law, and number 4 being overwhelmingly supportive of applying Minnesota law, I think you reach the same result.
So
Go
ahead.
Sorry. Wouldn't you agree that generally the presumption is the choice of law is where the plaintiff resides, and generally the plaintiff files in their own backyard?
I think
Now, if you guys are listening, also real quick, Ron asked a question here. I think, Ron, you just got in here. Is this Schneider? Is this Montegraph's attorney? No. That said, though, David Schneider is in the courtroom. He's sitting in the back right here. That's Monty's actual attorney. This guy here is the appellate attorney they hired. His name's Chris Bowman. And then this guy right here, this is Mark Randazza. That's Nick's attorney for everything. And then this guy right here is the Pro Hoc Vice guy, who's basically the guy who practices in Minnesota that allows Mark to be there. Now, if you guys notice, he's getting pushback already on the choice of law issue. And this judge is pointing out, don't you normally do it where you live? Because that's where your community, where you are, where the injuries happen. And I think this attorney was not prepared for the receptive response Mark got for the choice of law issue. Because they're not just saying, Minnesota good enough, we're calling it quits. He's getting a lot of push. He'll get a lot of pushback, and he's not prepared. Now, you guys can. I know people are making fun of his voice and whatever. Yeah, I don't. It's not like he's scared, but I think he just was thrown off kilter a little bit. And we all talk weird. I'm sure a lot of you think I talk like a weirdo too. So, I'm not gonna. I mean, this guy does appellate work. And the one thing I will say in a difference to him and Mark is Mark's been doing this for decades. This guy probably has been doing it. I've been doing this about 10 years now. Come May, June, I'll be about 10 years in. He's probably around my time, maybe 10, 15 years. It takes a lot of time to get a lot of appellate arguments in. And Mark, on the other hand, has been doing appellate arguments. He does them all over the country. I mean, he parachutes into hostile territory and fights it out all the time. So he's a lot more seasoned and experienced at that. And dealing with people that nobody likes. And because that's what he represents is First Amendment cases, and they're not, he doesn't take the popular ones. He takes the ones that are hard. Also the ones that pay, but those are the ones that pay, the ones that are hard. Also, given Mark's past in the porn industry, that's kind of a funny pun. Not intended, but it works.
I think, Minnesota and federal law gives plaintiffs the option to choose the forum, subject to, of course, jurisdictional and forum nonconvenience grounds, which isn't what we're here on today. And then you go through the 5, or really here the 4 Jepson factors. And I think you need to look then at, there was a lot of discussion this morning about how Colorado's statute out of the LSS case incorporates the summary judgment standard, and a suggestion that affirming the district court's decision and finding that Colorado's anti-SLAPP statute is inconsistent with Minnesota's Article 1, Section 4 right to a jury trial flies directly in the face of Leyendecker.
Counsel, that's not an answer to my question, though.
I apologize, Your Honor.
My question was, isn't it true that generally there's a presumption that the choice of law is where the plaintiff resides, and that generally the plaintiff files in their own backyard, which would be, in this case, Quest's backyard is Colorado?
I don't know if I would say that generally the plaintiff files in their own backyard. And as for, is there a presumption
We would go
that
way too fast,
the
Joe.
plaintiff's
That's too fast for that.
domicile controls the forum? Again, I think is inconsistent with, again, the Lohman case, where you have a North Dakota resident injured by a Minnesota resident. In that case, injured in North Dakota. And this court said, it doesn't matter, we're going to apply Minnesota's immunity statute.
Well, let me put it this way. I mean, my private practice was mostly federal, and we almost always filed in the plaintiff's backyard.
This is Monty's attorney,
it's
guys.
It's very unusual for a plaintiff to file in the defendant's backyard. You want to be in your state. You don't want to have to incur the cost of travel. There's an assumption that the jury is going to be more favorable to you. And you don't file it in the defendant's backyard unless there's a really, really, really good reason. For me, just speaking for myself, the first 2 factors incorporate the whole forum shopping. You want to avoid forum shopping. This looks.
So, guys, yeah, we could try to go faster, but for the most part, the attorneys in this case and the judges talk at a fast enough rate. I don't want to go too fast because it really kind of ruins what's going on here. But yes, if it actually, wow, a couple more of you diggers took you guys to get out of the tunnels. Joe was working you overtime. Thank you for being here. In addition to the ones who are already here. And I guess getting back to what, Monty's attorney real quick, there's, Ridge, you're saying, did the lower court already apply summary judgment standard? The court looked at it and decided not to, and said it was too early to apply summary judgment. So it ended up not doing that. Thank you for the super chat, by the way, for $5. So the court denied that. The court specifically said it's improper at this time. It's untimely now. That doesn't mean it's not proper later. Bebop and Rocksteady. Oh, they were the coolest guys on the show back in the day. Criminal, quick question. Did Nick hire good lawyers or no? Like, this is sounding favorable as far as thumbs up, thumbs down would work. I mean, I think it's indicative here. The court is receptive to the argument. Now, the intensity and ferociousness of the questions from the court doesn't necessarily indicate which side is going to win or lose. But they didn't laugh him out of court. They're actually hammering Monty's attorney with this forum shopping issue. So it's not like I think there's a chance here, and so overall right now I'd say thumbs up, but I'll give a better answer when we're done. Zathian says, you think a trial attorney would have some voice classes or something rather than stutter through his argument? Here's the thing. It's one thing I could talk to you guys right now, but in a courtroom full of people, I've sounded like I've got a bag full of marbles in my mouth before. It happens. And sometimes I get going really fast and I forget how the term is like, but I eat my words at times when I'm in court. It happens. Sometimes I've gone really, really fast. I'm talking so fast the court reporter's like, slow the fuck down, Hoss. That's happened to me before. So it happens. It happens to the best of us. And yeah, Michael Bergson, we don't have hesitancy. Sometimes, I mean, you go into regular courtrooms across America, you'll hear attorneys talk like they're half retarded once in a while. You just stutter or just trip up on a word. It happens. So trust me, I've been in his shoes before. So, and then Elegant News from 199, thank you, is saying sometimes soft and fluffier is not doing job. Yes. All right, let's keep going.
It's like forum shopping. When you file in somebody else's, in the defendant's backyard, because of the choice of law, because of the anti-SLAPP law being held unconstitutional. And so there is no anti-SLAPP law in Minnesota, which would be much, much more favorable for the plaintiff here request. Why, under the first two factors, why doesn't that favor then Colorado? Because of the overriding goal to avoid forum shopping.
I would respectfully disagree that this is an existence of forum shopping. You know, speaking to my former practice, where I practiced in railroad litigation, no, we didn't file every case in Dallas, Fort Worth when we were suing BNSF, but where the tortious conduct occurred was controlling. And here, Minnesota is not only defendant's backyard; it's also the forum where at the very least, allegedly, and I think, as the court correctly found, defamation per se, in fact, happened. I think you raise an interesting question of where the harm occurred, because the harm here, unlike the Northwest Airlines case in which the defamation had been submitted in a newspaper, local newspaper, it had subsequently been republished in Texas, but the focus was on the fact that it occurred in the local paper. Here we're now in the 21st century. The defamation occurred on the internet. So how does that play into it? And does Northwest Airlines case even apply, or should we really be looking at the restatement that looks more at the significant, I always forget the name of the significant relations test? I think again, I would submit that this court has established that you don't look at the significant relationship test. Minnesota, to my knowledge, has not adopted that standard here, and that Minnesota applies the 5-factor test. To your question about does Northwest Airlines apply in the 21st century with simultaneous publication, not only nationwide but worldwide, I think also questions then predictability of the results. If in Northwest Airlines, where a statement is made to a local newspaper before the local newspaper is also published online, I think that in that circumstance, predictability of results leads to a favoring of where the newspaper is published. Now, where you have simultaneous publication globally, predictability of results becomes much harder to square there, because if this statement, there's a suggestion that because this is submitted over the internet, there's then a predictability of Colorado. But to Judge Eid, your question, assuming without conceding today that both of these individuals raised to the level of internet celebrity, that reputation exists beyond Colorado. That reputation exists potentially globally. And then when you have a predictability question, it throws the whole thing into chaos a little bit.
And I tend to agree with you on that. I think it does, which I think makes Northwest Airlines a little maybe outdated. And so this court and the Supreme Court have relied on the restatement for when we're really entering into new areas of law. Isn't that what we're really doing here? Isn't this kind of uncharted territory that we're entering into? And if so, shouldn't we look to the restatement and what other courts have done as persuasive authority?
I don't think the court needs to go that far in this case. The court certainly could. But here,
Also, chat, you heard the judge talking about the restatement. So the restatements are treatises, and it's like a collection of discussions and thoughts on various legal topics. So there's like a restatement of contracts, a restatement of torts. There's a restatement of a lot of different areas of law. Restatement of did I say contracts? Okay, if I didn't. There's also a restatement of the conflict of laws. And now, what does a restatement do? Well, it gives you kind of like advice and guidance and laying out the principles of how do you assess conflict of laws. So when you're not sure where to go, I mean, that's a very basic building block area. When you're in legal writing, you learn that's a basic building block to start looking to help you figure out a subject in an area. And when you're in the law school classes that cover the survey topics, the basic ones, it's like contracts. You talk about the restatement of contracts. There's a restatement of torts, and they work on developing them. And every 10, 20 years, they try to release a new restatement, and it's law professors and scholars all over the country and practitioners working, and well, not necessarily practitioners mainly, but working together and putting together what they think should be the guiding principles that people should look to when they're trying to figure out what to do with the right thing. So that's why they keep mentioning the restatement. The restatement's kind of the basic building block. If you could start from there, and if you need overarching guiding principles for a lot of civil areas of law, you could start with the restatement, and the restatement will be very profound and powerful to cite as a source.
where again, I think the question before the court is whether or not the district court, or and this court is an error correcting court, it has a limited scope with that. And so if Minnesota were to formally adopt the restatement and say, Northwest Airlines was great for the time that it was decided, it doesn't apply in the YouTube social media era, respectfully, that would be a decision for the Supreme Court to make as a policy making court rather than this court.
And in fact, to the extent that the Supreme Court has applied the substantial or most significant relationship approach, hasn't that, I think that they pretty clearly said in Castillo-Alvarez that they're going to apply that test when the issue has to do with both a procedural and a substantive purpose. And I think that appellant was pretty clear in their argument that they're not arguing the procedural aspects of Colorado law. They're only arguing the substantive purpose of Colorado law, which would indicate that the most significant relationship approach is not what the Supreme Court would ask us to apply.
Precisely.
I have a question. So I think that my issue with factor number one has to do with if your client had filed this claim in Colorado, I expect that your argument would have been, my client lives here in Colorado, and this is where most of his friends and relationships are, and therefore his reputation is most harmed in Colorado rather than in Minnesota. And I do think that when you look at the federal cases that are starting to wade into, in the internet age, what do we do? In defamation cases, often they say, well, a person's reputation is most harmed in the place that they live. And so is there a reason why we shouldn't think about that in context of the first factor?
I think that weighs in. Again, I would submit that there is some question about whether or not Mr. Quest is in fact a Colorado resident and resides in Colorado. But for the purposes of this
in the complaint, is it alleged that he's a Colorado resident?
Yes, and so for the purposes of this appeal today, I'm not arguing that it's not. We would recognize that Colorado meets that second step of Minnesota's choice of law framework, where there are sufficient contacts of both Colorado and Minnesota for global constitutional perspectives, either forms or either law to apply. Also, this court has recognized, and I think this analysis does survive an internet age evolution of society out of Northwest Airlines, where that first factor has less relevance in situations where they're not consensual transactions, where everybody knows in advance what law is going to apply. When we do business litigation, we put a choice of law in most agreements. So our client, the other client knows, hey, if there's going to be a dispute, everybody's agreed Minnesota or Iowa or Michigan law will apply here.
And counsel, I actually agree with you on that point, speaking only for myself. I think that is a correct analysis. But then the first factor, I think, goes to the underlying issue of avoiding forum shopping then, right?
Well, which I think the district court analyzed as the second issue, or the second factor, maintenance of interstate and international order. I think the district court did in fact find that they thought this was forum shopping and that factor did weigh in favor of Colorado law. Do you disagree with the district court's finding on that?
I disagree that maintenance of interstate order supports Colorado law. I see that my time is almost expired. Do you mind if I fully respond to the question?
And sorry, Judge Reyes, if I restated your question.
I want to make sure I'm answering all the court's questions. So I'm going to respond to Judge Larson, your question first, and then I'll look to Judge Reyes and make sure that I've answered any questions that he has. We would dispute that the maintenance of interstate order factor supports application of Colorado law. The Colorado Court of Appeals, different divisions, can't seem to agree on what this statute means and what standard apply. This statute meaning Colorado's anti-SLAPP.
So you're saying there are other cases that have held it's not a summary judgment standard?
Yes.
Okay.
Specifically, Salazar talks. Give me a moment. I have 522 Pacific 3rd at 248. That's a pin site for it. But talks about how the division held the court neither accepts the allegations as true nor determines truth, but must assess whether the allegations and defenses are such that's reasonably likely that a jury would find for the plaintiff. And then you get into almost the constitutional avoidance analysis that the Minnesota Supreme Court rejected in Leondecker 1, that the language of the statute is not consistent with a summary judgment standard. Judge Reyes,
I would like to, if you'd respond to Judge Reyes' question.
And I apologize, Judge Reyes, would you mind re-asking the question?
Sure, if I can remember it. I know what it was. It was on the first factor. So I basically said, I speaking for myself, I tend to agree with you in terms of the business relationships and with respect to the first factor. But I think there's still case law talks. The NODEC case talks about you still want to avoid the forum shopping. That's still part of the factor consideration, even under the first factor. Correct.
I think avoidance of forum shopping, yes, it is a consideration in the first factor. I would agree with that.
Okay, thank you.
Thank
Can
you.
I ask a couple of questions? I think you were trying to at some point get to the fourth factor, and just to sum up, since your time is done, perhaps you can give us your best argument as to why you believe that factor so heavily favors application of Minnesota law.
Sure, Your Honor, and I will do my best to be brief as the blinking red light grows ever near, or as in fact here. In the Leondecker decisions, this court at first tried to frame Leondecker as a Rule 12 analysis, or frame Minnesota's anti-SLAPP statute as a Rule 12 analysis, despite the language of the Minnesota statute not being a Rule 12 analysis. The Minnesota Supreme Court said, no, you can't do that. It's not a Rule 12. This court, in fact, recognized, hey, if this isn't Rule 12, it violates Minnesota's constitutional right in a footnote. And I believe it was Judge Connolly's decision in the first Leondecker appeal, or the first Leondecker appeal concerning the anti-SLAPP statute. And the Minnesota Supreme Court in Leondecker 2, I believe 2017 decision, talks about how Minnesota has a constitutional interest in affording a jury trial right and submitting a claim to requiring the court to make a determination, which even LSS says that the court has to make under the anti-SLAPP statute, would violate that right. So unless the court has any other questions, thank you, Your Honor.
Thank you.
All right, guys, real quick before Randazza finishes, I want to get a couple things. Slade, get to 10 memberships. Thank you, Slade. Whoever gets those, I know is going to be thrilled. Greg also gifted 5 memberships. Thank you, Greg. I know whoever gets those will be thrilled too. Casey Norcal says, is what they're doing similar to the Erie Doctrine case? So, guys, the Erie Doctrine case is when federal court, if you're doing things under state law, cause of action, federal courts apply the state law that you're trying to fight over under. So, for example, Gina Carano's case against Disney, she's applying California labor laws in federal court. So the federal court's like, all right, cool, we'll use California laws. Let's go. Let's do this. And that's the Erie Doctrine. Here, I mean, it's kind of like that. You're forcing the court to use what's the appropriate law. So in this situation, like I said earlier, this is a Minnesota court contemplating whether or not they need to apply Colorado law. Like, what's the proper law here? And that's where you go from there. So in a way, it's kind of like that, but it's not. I mean, not really. But I get what you're asking there. Like it's not the worst analogy in the world, but it's not probably the best. And I know there's people out there who are smarter than me, probably come up with something better. Pillow Tap says, so in appellate arguments, you only have a limited time to speak and you have to answer judges' questions. Seems rude. If you didn't, these would take forever. Just like the Supreme Court of the United States. When you're up there, the judges might eat up all your time. Sometimes you get to speak. Now, if you get through the whole time and nobody asks a question, that's not good. But there are times where there's back and forth and you're getting questions and they'll let you state your piece. But I've also seen oral arguments where it starts off the bat and your honors may please the court. And, where I'd like to, the judges start asking questions right off the bat. And they eat your lunch, all your time. They take it all. That sucks, but that happens. They have the right. They're trying to figure things out. It's about them asking, it's not like you could say, hey, whoa. I love you judges. Let me finish first. No, don't. You're in their court, man. They're going to ask their questions. So no, they can do that. I've seen it happen. It does happen. So that's just how it be. So let's just finish up Randazzo real quick. He's only got a couple minutes.
Counsel for Appellant, you have 5 minutes and there's a little shuffling behind you. So
Thank you.
I'll give you a sec. You can feel free to adjust the podium if you don't want it that high.
I can roll it.
Okay.
So I want to address the what choice of law furthers Minnesota's interest first. Now, Colorado has forged a legal regime that protects its citizens from defamation while refusing to let that value impede on First Amendment rights. Essentially, Colorado has said you have this much latitude when you're talking about a Colorado reputation. And I don't see how it furthers Minnesota's interests to say that if you're a Minnesota resident, we can strip you of that protection as long as they come and forum shop into Minnesota to get a different result. Should a Minnesotan have weaker rights than a Coloradan when you're debating over a Colorado reputation? I think that you'd be doing the exact opposite of serving Minnesota's interests.
Counsel, can I ask a question? Do you disagree with respondents' argument that Colorado actually hasn't settled on whether it's the summary judgment standard that applies to the Colorado statute or not? And I guess I'll just tip off that where I'm going with this is on factor 3 with regard to the simplification of the judicial task.
Yep.
Are we really going to be sending this back to the district court to have to resolve conflicts in Colorado law here in Minnesota? Because that would seem a challenging task for a Minnesota judge
It would,
to do.
but fortunately, you don't have that problem. His assessment of Colorado law, with all respect, is wildly incorrect, not even close. And the case he cites for that proposition is a California case. So California, looking at the California.
So
case
can you just so the case that you're citing for the summary judgment standard, can you just explain, is that what we would consider here in Minnesota a precedential decision that's binding on all the courts, or is that just because I don't think you cited to the Northwest Reporter. So I wanted to, is that a binding case on all the courts, or is that a non-precedential decision that's more advisory? Because here in Minnesota, we would have a distinction in terms of the weight that we would give to that kind of case. And so I guess the case that you're relying on, what is the weight of that authority?
It is the most recent appellate decision out of Colorado on it. So I guess you'd look at it like if you were in a federal court, the federal court would have to follow that. So I don't think we have
the district courts in Colorado would have to follow the decision that was, okay, thank you.
And as far as simplifying the task, I think I didn't give a very satisfying answer to Justice Eade when you asked me a question, and really it was so fundamental. The predictability factor, simplifying the task. Remember, there's all this discussion of, well, why would you think that a Colorado reputation would be governed by Colorado law? Well, Calder versus Jones out of the United States Supreme Court made that very clear. Now, that's a personal jurisdiction case, but the reason that personal jurisdiction was in California in that case was because the United States Supreme Court said very clearly, your reputation is where you are. Unless there's some overwhelming reason not to be. Like I could see maybe if Stephen King.
Can you remind me the year of that case? Is that a case from the internet age? Because I think respondents' argument is that this person's reputation is really on the internet. And so where his reputation was harmed was globally or across the entire United States, and that is his reputation is no longer really located in Colorado, given this particular person's lifestyle. And
well, then let's adopt that. Then why not Hawaii law? Why not California law? Why not Massachusetts law? I mean, I think that we have to have some predictability, and that predictability is I mean, when I do pre-publication review for publications, they come to me and they say, we're going to write this story. And I say, where does the subject live? That's how everybody I know who does pre-pub review does it. Says, where are we going to wind up getting sued, or what state law are we going to look at?
Now, that's a really great answer by Randazza. I do this all the time. You know, this specific thing of figuring out what law applies based on if somebody tries to sue us based on statements made. And that's true. There has to be some standard. And the standard should be where that person lives. I mean, that makes a lot of sense. He's making a really, really good point, because otherwise you can apply whatever state you want to. I mean, if we're making the argument, well, the internet's everywhere, fine. Monty could sue Nick in Hawaii. He could sue him in France. Now, I don't know how the long arm. Let's assume Nick was subject to the jurisdiction of France or Slovenia. Well, Slovenia is part of the EU, so that won't work. But let's say he went to Kazakhstan. Like, it's all over the world. They could go to Swahili land and go do this, or they could do it out in the townships of Johannesburg. They didn't get AIDS or robbed or lit on fire with tires. But he's pointing out that there has to be some level of, we have to start somewhere. We have to have a standard. And it may not be the best standard, but we got to have something. There has to be a baseline. Otherwise, this is just a mess.
So predictability, I think, at least in the online publication world, would be thrown into chaos in Minnesota if we decided that somebody whose reputation is everywhere but lives in a specific place, that their reputation should then be managed under Minnesota law. And remember, again, if he sued at home, it would be a different result. So Colorado law needs to apply here, unless you would like a different result for Minnesota residents, which again strikes at the core of what Minnesota's interests are. I think Minnesota's interests, if anything, should be that its people are free to speak in the same way that everybody else is, not to say that they're going to wind up getting sued in a libel tourism case by somebody who comes from one of the 35 anti-SLAPP states. And again, to remind you, sorry, I'm done. If you have any questions for me while I'm still up here.
Thank you.
All right, thank you very much. And thank you, Monty.
Thank you to both counsel for your arguments in this case. This case has been submitted and we will issue an opinion in the time prescribed by statute. Thank you.
All right, so there's 90 days till the court. They have 90 days under Minnesota law to knock out a ruling. So 90 days from now, we'll figure out what happens. Maybe sooner. I doubt too soon, but we'll know soon enough. As far as there are some questions I did want to get to here. What I think the odds are this goes in his favor. I mean, based on the way the judges are looking at it, I'd say he's probably got a decent chance, but that doesn't change a whole lot for him ultimately. And the only reason why I bring that up is because if you go to what Colorado's anti-SLAPP statute says, and this is its anti-SLAPP statute here, this bad boy, Colorado Revised Statute 13-20-1101. What does it say? Well, it gets down to here, and it says a cause of action arising from any act that furthers the person's right to petition or free speech under the United States Constitution or the state constitution in connection with a public issue is subject to a special motion unless, and here's the thing, the reason why this becomes an issue regarding the First Amendment is you're asking the court to silence someone. So that becomes governmental action. The same reason why if you have a racially restrictive housing covenant, like you can't sell the land to black people, you can't sell land to Jews, whatever. Those are unenforceable because if to enforce those, you would have to go to court. And that means you're using the government to enforce racism, which the government's not allowed to do anymore. So there are limits to what the government can do, and through the courts, it becomes government action. So it's subject to a special motion to dismiss unless the court determines a plaintiff has established that there is a reasonable likelihood they will prevail in the claim. So that's the standard, a reasonable likelihood that Monty would prevail on his claim. And that is the standard there. Why did that? And if the court determines that, that's it. It moves on. Now, in this situation, what happens to Nick here? And one of you guys saying, Andy's saying, well, if Monty loses, what's his recourse here? So there's two ways this goes for Monty, and they're not bad. And for Nick, even if he wins, this doesn't change a whole lot either way. because there's two ways this can turn out. And we'll finish this up real quick, guys, and we'll get to the Fani Willis, Terrence Brandon text. So there's two ways this ends up going. So here's the decision, and then it comes up to win, and then there's loss, okay? So there's the L, and there's a W. So this is the Nick situation, and this is how Nick would look at it. Nick's got two options. He's either going to get a favorable ruling or a not favorable ruling. There isn't a kind of, there's no kind of maybe here. Either Colorado law applies or it does not. You can't halfway do it. So if Nick loses, he's got two options. You know, his options are then just go straight to back to the case, or he can go to the Minnesota Supreme Court. Okay? And that's not going to get him anywhere. So what's Nick left with? He's left with discovery. Okay? He's left with going to discovery. Because that's where they are. Which means admission, requests for admissions, interrogatories, discovery demands, depositions, all that fun stuff that happened in the Vic Mignogna case, all those things we watch, that stuff's going to happen. So that's option one for Nick. Option two is if he wins. Okay, so if he wins, it still goes back to the trial court. But he could still lose because the trial court can look at it and say, okay, under Colorado law, it's defamation per se. There's a reasonable likelihood that Monty will win. And that's the reasonable likelihood is that standard for the anti-slap motion only. The motions, if Nick later on files a summary judgment after discovery, things like that, those have their own standards and burdens of proof. But for right now, he does have that limited reasonable likelihood. The judge will say, okay, yeah, there's still a reasonable likelihood. Don't give a shit. Colorado law, still don't care. We're going to discovery. So Nick from here, even there, he can still win. Or from there, he can lose. And now if he wins again, and the trial court looks at it and says, yeah, you know what? There's no likelihood Monty would prevail. Case dismissed. So Nick can win and still lose. That's the thing here. Him winning doesn't guarantee a win happens at the trial level. So there's a lot of ways this can turn out. The one way I can guarantee is not going to happen is him going to the Minnesota Supreme Court. They will not overturn this. Getting heard by your state Supreme Court is almost as hard as getting heard by your United States Supreme Court. It's really fucking hard. So that's my answer there. Seize the day for $2 for 2 loonies and 79 cents. You know what you call them in Canada, cents? It says, we the people stand for the Pope, bring it home. Thank you. Aaron says, oh my God, I live in Minnesota. Do I sound like her? Probably. You probably do. T King says, lawsuit on the moon. Yes, that'd be perfect. And Tilly says, all of this lawful law. Yes, it actually is lawful law. And Winston Smith says, Monty's attorney is getting a hot bench. Yeah. And that's the term, a hot bench as a judge is where there, a lot of activities going on. So yes, that was a very lively appellate argument. The one right before them was about some like children's services case, and it was really kind of boring. So this was a little more lively. So that is that, guys. We'll see what happens. I was surprised at how that turned out. So we're going to move on to yesterday. Fani Willis had her reckoning, and it was reckoning through the attorney that Nathan Wade hired, Terrence Bradley. And if you guys remember from a couple weeks ago, Bradley was on the stand and kept asserting attorney-client privilege and kind of ruined everything. Well, the judge involved, Judge McAfee, said, I don't think you're saying all this right. I think you're bullshitting us. So guess what I'm going to do? I'm going to make you come into chambers, and you're going to tell me everything you're claiming is privileged. And he did. So Judge McAfee heard it all, and he released a ruling on Tuesday saying, yeah, I just listened to him. He's full of shit. All the issues regarding privilege between Nathan Wade and Terrence Bradley in the time frames that we're talking about through 2019 or so don't exist. So there's no privileged communications there. They are all exposed. This is also the same guy that when he was on the stand, the district attorney's office was grilling him about the sexual harassment that he got fired from the firm for. which I still don't understand why they did that, but hey, whatever. I'm not as smart as them. So he came into court on Wednesday, and the attorneys that were going after him had stacks of the text messages that he texted to Trump's attorneys, the guys on Trump's team, where he told them everything. He fucking told them everything, guys. I'm not joking. Literally everything. And it's hilarious because those texts have been released and we can actually read them. And they are good. They are good. There are so many of them, and they are very, very interesting. So hold on, I gotta get sorry, I thought I had these all open yet. I gotta reopen them all. I accidentally lost them. Now, when we were listening to all of this, they are still bound by the rules of evidence and how they can present them, but now we've got them, we can look at them, we can kind of shortcut all this stuff. And it's very interesting because somebody committed perjury. Now, Terrence Bradley said, I was just speculating when I told the attorney all this stuff, which is hilarious because if he's speculating, he's 100% on the money. Now, why is this a big deal? Because if he really did breach privilege and he did talk out of turn, you can get disbarred for that. That's a big deal. That's up there with stealing client money. Breaching confidence like that, oof. Now, that said, I don't think that's going to happen to him here. Why? Because, well, Georgia seems pretty corrupt overall, so I think he'll be protected at the end of the day. But Fani and Wade, well, they've got their own problems. And do I think I could see them getting disciplined, but is anybody going to prison over this? No. That's just not how this is going to happen. But it is very interesting to see what they're talking about because this just goes on and on and on and on and on. And there's just so much, and it's hard to believe. So hold on here, guys. Sorry, I need to. All right, so hold on here. Where are you guys? Said BLTs, but they're criminals. Yeah, well, they're going to get away with it. That's how this goes. Slap says Bradley was texting Ashley Merchant trying to get a little lovin'. Now, if you guys don't remember, Ashley Merchant is the blonde attorney who's been kind of leading this charge, and she's got the big old sweater puppies, and she was leading all of this. Revenant saying dramatic reading session for the text in the future. Maybe. Maybe I can get 2.0 to help me with that because it's a little awkward reading them all by myself. And unlike the lead attorney, I don't have AV to the 7th with me. So maybe we'll do that in the future. Maybe that'll be a members only thing. So here we go. Here are the things we're looking at. Elegant saying for 199, there's so much is what Fani said. Yes, there's very much in what Fani did say. She said quite a bit. Yeah. Dog Backwards says, not for 9 months anyway. Success will be our revenge. From your lips to God's ears. The Last Imperial is saying, well, I look at the Rush shooting case. So here's the thing. I will be looking at that. I look at that tomorrow night. Every Thursday night, I do a live show starting at 9:30. I do it every week. That's one of the things we'll be talking about is the Rush shooting and how things are looking. Right now, things aren't looking very good for Hannah Reid. I mean, she is coming across as the most airheaded and incompetent person they could have had out there. It sounds like all she did was screw up. But we'll focus on that more when it comes to Thursday night because we'll have time to look at that and really take a look at what's been going on. So remember, Thursday night at 9:30, that's my live show. That we'll definitely be talking about it there. I will just say, yeah, it's not looking good for her. It's not looking good for her. And I don't know why she decided to take this to trial. Because there's stuff now that doesn't make any sense at all. But getting these text messages. So This is where things start, and it's interesting because Terrence Bradley and Ashley Merchant know each other. These attorneys all know each other. Fani Willis, Nathan Wade, all these guys all know each other. So these guys are talking all the way back in September of 2023 about this stuff. And this is not the full list of things, but it's the beginning of stuff here. So FCDA is the Fulton County District Attorney's Office, and they're saying they don't have an original contract for Nathan Wade when the work began. They only have his renewal contract. Is that possible? And she attached all that, and he says, "Wow," and she's like, "They're stalling big time." Yes, they are. So these are friends that are kind of just bullshitting right now. Now she's pumping Terrence Bradley for information because he knows Wade. He knew them. She's like, "Who can I talk to about getting an affidavit?" And he said, "No one would freely burn that bridge." Well, I guess we found out who did burn that bridge ultimately, Terrence. Now he knows who they know. He knows who knows. She's asking, "Would a guy named Chris do it?" And he's like, "No." And he's saying he knows, but he won't admit to it. So we have that, and now we're getting into here. We're getting into January of 2024 when the motion got ready to get filed. So she starts talking about, did Fani go on a trip with them last summer in May or June? And he says, "I don't know. I was gone by then." But then he says, "It doesn't surprise me. They took many trips to Florida and Texas and Napa." And he says, "California." And she says, "Yep." So he's already dropping bombs. Yeah, they've been to Florida a ton. They've been to Texas a bunch. They've been to Florida a bunch. So you can see when she filed this motion, she had the goods. She talks like they had a full-on relationship. He's like, "Yeah, they went to help her move." Why she would hire him is insane. Yes. She's like, just date him, don't hire him. Yeah, Fani should have done that, but she didn't. And then she says, "Do you think it started before she hired him?" Absolutely. And this is where he says, it started when she left the DA's office and was a judge in South Fulton. So he's already admitting, yes, this happened way back then. This is just... Hold on here, guys. What is this? Okay, so... and then he talks about when did they meet. They met at a municipal court CLE conference years and years ago. So, and now this is the interesting part here. This part here, guys. Upon information and belief, she's asking, is this accurate? Because she's saying, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at the time. This is her trying to have him proofread parts of her brief. Are these facts correct? And he says, no, in the municipal court. So he's correcting her, saying, no, your motion's wrong. You need to fix that part. But the rest of it's right. Notice he didn't correct her on the rest of it. He just says, change this part about the magistrate judges. The rest of it's true. He says, but you can't put where they met. Many people don't know that. So he's trying to be a source without making it clear he divulged information. Because not enough people do, and they'll figure out who did it. Now, maybe he's worried about his safety. I don't know. Then Terrence Bradley says, I might be one of the only people, one of only, not even Chris Campbell. And that's... hold on one second, chat. Sorry, chat. I thought that was sharing with you guys. So, anyways, we get to the part of the big stuff here. This idea of, is this accurate upon information and belief? She's asking this guy to correct her stuff. And this is the way she filed the motion. was based upon his information. Lead says Terrence was chasing his first white pussy. That doesn't surprise me. Although she's happily married. So, yes, this is how she figured out what's going on. And Terrence Bradley had to spill it all. We then get to this part here, and these are really good. I'm almost done with my motion. I'm not filing you till Monday. Can I send you a draft? I can't wait to hear about your trip. And he says, okay, happy hunting. To your knowledge, has Nathan Wade ever prosecuted a felony? I can't find a single one. Nathan Wade has never prosecuted a felony. This guy handling the Trump RICO case, one of the biggest cases in American history, indicting a president and all of his men. And he ain't never done a felony case. What the fuck is going on? I mean, really, what is going on? And that was the research everybody else found. They're like, what the hell is this guy doing? He doesn't know what the fuck he's doing. But Fani wanted to pay him. Wanted that Gibbs me that. Pay him up. He says it's bad. Send me a rough draft. So I don't know how he must fucking hate these guys. He doesn't let it show on the stand, but he must. I mean, I think he hates Wade because they forced him out of his law firm and made him give up 20 G's to that sexual assault victim. So you can just, I mean, they talked about these in the hearing, but now you're seeing them. You know, this guy's chasing white pussy, but he's also fucking hating some people. He hating Fani's ass. Fani's all flat-faced ass, and hating Nathan Wade. Hating the fuck out of them both. Now, he's like, it's okay. You can add me to a footnote and tell everybody how much I made. He's like, throw me in there. Include me. Think about how fucking, like, you know, it's so funny. He's like worried, but he's like, don't include me. But then later on, he's like, fuck it. Fuck these cocksuckers. This is very interesting. Yeah, having your enemies fight each other must be the best feeling. Yeah. This is just very, very, very interesting how they did this. Yes. So this is, oh God, this just gets, you know, he wants to help. He wants her to, like, you know, have you noticed me yet? You know, yes, add it back. It's like, it looks good. Can I do anything else for you? Can I help? You know, how will they respond? Did you look at the campaign contributions? You know, I can only imagine the amount of shit. Like, if you could give him like full immunity and promise him, like, we promise Fani won't send people to kill you. We promise Hillary won't send people to kill you. If you could guarantee him all that and give him like witness protection and gave him a ton of fucking money, the amount of shit he could tell you that Fani did, I bet is, well, it wouldn't surprise any of us, but he'd be like, how much time's that tape recorder got? Because I got a lot of stuff to tell you. He says, I can't remember what we gave her when she was running, which, yeah, I mean, they gave money. Okay, that happens. It does get interesting, though. He knows how they're going to explain stuff. They won't attack you. They will deny it, but they're not going to attack you. And he knows he's just like, they're going to deny it. And notice he doesn't correct her, and that's part of the thing here. That trips and cruises were for work, even though they didn't submit them for reimbursement. Yeah, and, you know, that's the funny part about Fani's story. Well, I paid in cash. Okay, why didn't Wade seek reimbursement? And if they were for work and you were paying in cash, why would you pay in cash? Well, you know, Fani's like, it's a black thing. We keep cash at home. It's like, no, keeping cash at home is a get robbed thing because people come rob you when they know you got cash, which I'm surprised that hasn't happened to Fani. No, like, people now know, hey, she got a ton of cash at home. Like, go knock her house over. Not say do it, but I'm like, that generally happens when people on the street find out there's cash. A lot of cash sitting around. Now, Terrence Bradley points out, like, do you know when she was elected? He was on her executive team, and he was part of all the interviews for people she hired or fired, and that she went through everybody, and the guy she's fucking is in charge of determining who gets fired and who gets stayed. Yeah, yeah. She points out, like, no, Fanny has a private security detail. Now, does she really need one? I truly doubt it. I mean, maybe she does, but I'm sure she uses them as her own little thug squad and her own muscle to do things. 'Cause that's usually what happens when people have a security detail. They turn into your hired muscle after a while. So that they would be at her office, and they would take them to dinners everywhere. But they changed, and it's like subpoena their original security detail and the current detail. You know, you really want to talk to the guys when she was initially elected about where the money and all the shit was going. It's like, this dude's snitching for free. Yeah, he's trying to burn Fanny and all them for a crumb of pussy. He's like, I want that white woman. If I give her what she wants. Oh, Lordy me, oh my. I was about ready to eat. And sadly, he didn't get to eat. Womp, womp, womp. So, yeah, it's like, get the security details, boss. Can I just get that crumb of pussy, please? He wants to help. And, yeah, he's giving it all away. Giving it all away. Yes, me oh my. Yes, sir, yes, sir, yes, sir. KJM says, YLA, you mean the lead attorney says Atlanta is dangerous, especially for what? I mean, shit. That's why you get fucking straight. Fucking. If things are bad, protect your fucking neck. I mean, it ain't that hard. What do you think? Then, like, fucking, like, you get motherfucking guns. Strap up, son. You fucking drop a person or two, people tend to leave you alone. Look at Kyle Rittenhouse. Smoke a couple of fucking people, and all people will do from then on is talk shit about your ass. Ain't nobody coming at Kyle Rittenhouse because he already killed 2 men. So you already know he can do it. That's all it takes. Oh, yeah, Fulton County's dangerous for DAs. Yeah. She doesn't need a security detail. She can get a cop to watch over her. But hiring her own goons is what she did instead. So, yeah. Yeah. And they talk about, it's like, other than the relationship, who else could talk about the romantic relationships? Maybe her kids. Her kids definitely could. Her command staff, sure. Her administrative assistant. I mean, he's tipping it all off. He so wants to help. He so wants to be like a good boy. And then, and yes, there really is this whole this really does get a little awkward after a while. Based on how he does things. There's just so much of this, guys, that is so weird. This is a great example of, like, just how creepy it gets getting here. Like, without evidence of sex, he paid her for the plane tickets and travel. He's like, subpoena them all. She's like, I'm so nervous. This is huge. And he's like, you are huge. Now, is that him saying, like, he likes big white women, or he's saying, like, you're huge, like, you're gonna be great? And he's like, you will be fine. He's trying to get out of that friend zone. He's trying to get out of the friend zone here. You are one of the best lawyers I know. Go be great. And she's like, thanks. And she friend zoned him up on the stand, like, you're a fucking liar, ain't you? And he's like, and he's just sitting there like, I got taken advantage of. I fell in the pussy trap. And that it's just and then her question, and she asked another question like, how did Sonia, and that's Wade's wife, feel about Fani taking her man? And he's like, not sure how he feels, but it started out romantic, but when they left, it was more brother sisterly. But it's like occasionally they'd mess around, and I'm like, do you really want to include that term when they're being like brother sister, but then they mess around? Like, that's. I mean, I get they're in Georgia, but I just don't. I don't. Why do we have to do it that way? Because that's just. Ugh. I just this whole thing is funny. It really is funny when you look into it. Yeah, he got catfished into a firing squad. Yes, she catfit. She lured those crumbs of pussy. He just followed him down the trail like Hansel and Gretel. He walked right into an ambush. He thought it was going to be skiing down Snow Buddy Mountain. Yeah, I know. Oh, yeah. Oh, this is one of the DAs under fire that he had an affair with Sonia Allen. Oh, okay, McKinley, you corrected me. Sorry about that. There you go. That's getting corrected. Although, guys, really, at the end of the day, I just want to say this case, it's all about defamation. It's all about defamation. But, yes, Merchant, she's got a particularly good set of good skills and is good at making Joe yell at her. I know Joe did not like her, but she did a goddamn good job. She set this all up, and then Sadow came in and knocked it down. And we're gonna one of Bradley's comments, you can hear him go, "Damn," on the stand, and it's great. It is just perfect. Yeah, really, it's a case about family. Yes. It's yeah. So they then keep going on and talking about like, he's like she needs to fire Nathan, but she won't. And then he talks about Fannie Wills speaking, and that's when she went to the black church. The black church. The good looks when you get to rise up. It's not Fanny didn't say that, although Fanny looks like she's got the kind of shoulders and face where she could talk like that. Terrence Bradley says, I hated her painter in the black church. Nathan, he was good enough for the white Republicans in good old Cobb County, but not good enough for me. What's the difference? Man, he's so fucking mad. He's mad and looking for puss. That's interesting. So, oh, yeah, these are interesting. Very interesting text messages. There's some more friend zoning here, unintentionally though. So this is where Merkin's saying she's subpoenaing Chris Campbell and a bunch of Nathan's office stuff. And she talks about whether or not she's going to subpoena him and is he okay with it. And he's like, I'm okay with it. However I can help you. And then he says, you are a friend and I trust you. They will not. They're arrogant as fuck. She thinks she won the other day when she didn't have to be deposed. Which is funny because then what did Fannie Wills' dumbass do? Instead of being deposed, she comes running in and says, I'll testify, and then literally stomps on her dick on national television. Brilliant job, Fannie. Brilliant job. We covered that. It was brilliant. But yes, you are my friend. You have no idea. You just got friend zoned completely. You got used like a fucking tampon. This is just bad. So this is interesting though. The one part that I thought was interesting they didn't get to is like Nathan Wade maybe committed some financial fraud because she said his finances looked like he owed a lot of money when he began this. And he said, not true. Owed to who? Loans. He just might be leveraged. And he says, that's just on paper. And she's going to say, what do you mean? And I don't think we've got that part of it. But it sounds like Nathan Wade may be committing some financial crimes there. So, oh boy, Like I said, somebody might be getting investigated by the FBI soon. So yeah, very unbreaded. No bros before hoes there. Well, that bro threw you out and made you lose $20,000. So that'll make you forsake any bro at that point. Just saying, if your bros do that to you. Yeah, MLP says, wow, he's a fucking sieve. Yeah, and just telling everything. Just everything pouring out. Potatoes After Dark says, it's never Rico. Okay, in civil cases, definitely, it's never Rico. That was the only other thing I will comment on, because I commented on that before. I'll do the, the black people clap, like, it's never Rico. Like, yeah, it's never Rico. It's never Rico in a civil case. And in criminal cases, is Rico? Well, it shouldn't be, because Rico was something the government had to make up because they couldn't beat the mafia. We can't beat criminals. We got to make another law. So they made another law. Bebop and Rocksteady again, saying for $4.99, probably because they didn't have Bradley's back on the SA rap, and he was like, okay, fuck you then. Also, if it was a fast white girl like Merchant is a hell of a drug. Yeah, well, to be fair, I don't know how they would have, he was doing really, like, that's the part of this I still don't understand. Terrence Bradley was holding the line, asserting attorney-client privilege the whole fucking time. And then what did the DA's office get up and do? They fucking lit him on fire by talking about the sexual assault stuff. I don't get it. I don't get why you would do that. The guy has your back, and you're just like, fuck it, kill him. I joke, but maybe they were like, no, wait, call off the hit. It's no longer greenlit. Don't do it. And it was too late. It's one of those, fucking what movies where they get the hitman and they're like, sorry, it's already in motion. I can't stop it. I don't know, but I think it's this is really good. This is Bradley testifying, and this is him under cross-examination, and his response is just amazing. You can hear it, and you're gonna hear him talk about it, and it's really good because right now he's getting, in this clip I'm going to show you guys, he's getting grilled by Steve Sadow. He's Trump's attorney. And I've said this before, and Sadow was great. He did a really good job at cross-examination of this guy. He fucking lit him up. I mean, what I saw, especially with Sadow, like it reminds me like I need to practice my skills and get better, because it was watching a really good class in cross-examination. And he just savages, Bradley here and does a great job. But also just listen to Bradley's response when he realizes he's fucked, because it's really good. It's really, really good. Max saying, almost 4 p.m. here. Gotta hop. Max prayed to have dreams of Ashley Merchant and not pug-faced Fani. Yeah, well, that would be true, Max. Yeah, you definitely don't want those dreams. But anyways, have a good one, Max. Say, is it 4 p.m.? Well, yeah, I forgot they're that kind of year behind there. Yeah, Steve's got 30-plus years under his belt, which is weird because Trump usually picks really shitty attorneys. But this time he picked, like, the best fucking assassin he could. So, good for him in that regard. So, here is this. This is so good. This is so good. This is just so good, guys. So, here we go. This is some good stuff. So this is Bradley testifying on the stand. And you're going to hear Steve Sadow. He's via Zoom.
Was 2 pages of text messages between you and Miss Merchant, correct?
Correct.
All right. Now, the first page starts off by saying, Miss Merchant, like, just date, don't hire him. Do you think it started before she hired him? You see that?
You can hear it. He can hear it. He says, dang. He was so wrapped up in trying to get in there. He's trying to slide in there. He's like, I'll tell you anything you want to know. And he's like, damn, I said that. You know, he's sitting there getting ready, trying not to beat off. And he's just like, damn, I said that. That's what happens, guys. You get your eye on the prize and you forget. Just listen to him again. Yeah. Let's one more time for effect. Dang. Just silence.
Yes, I see it. Yes.
Just dead air afterwards. Dang. Like, those fucking mics in court are very powerful. Yeah. Yeah, it was at this moment he knew he fucked up. Yes, that's what going after that puss. Man, he wanted Ashley. He wanted to go help Ashley get her mud sharking on, but she didn't work out so good. Mr. K, as Drex would say, German Shepherds, man, except he was going after a white girl, so she wasn't. Ashley's not a German Shepherd, so I wouldn't say that, but you know, he wanted to help Ashley burn coal. It's like, didn't work out, man. You got caught. She used it. Yes, this guy was wiping his face with a hanky multiple times, wiping his head. He was sweating. He was sweating. Yeah, they definitely had him. And the best part of all was when he tried to say, "I was speculating." I was speculating the whole time. I'm sorry. I was just speculating the whole time. My bad. And it gets even better because that's what, you know, I was just making it up. I was just fucking around. Turns out I was entirely right, but I was just faking it.
Was this speculation when you told me that? Was that based on things that had been told to you and things that you had witnessed?
I never witnessed anything. So, you know, it was speculation. I can't tell you anything specific if that's what you're asking.
You can't tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean, I don't recall, but no, I don't.
Did you have any reason to lie?
Ah, she got him. It's like, well, why were you speculating? He'd just be like, because I wanted to get in your panties. Why didn't you just admit it? I wanted to get in your panties. He'd be like, girl, you ever been mud sharking before? Let me tell you, it ain't about fishing, girl. Let me show you. Come on over to my house. But he didn't do that. But it's like, are you lying? And he's just like, no. I love that. He's just like, no.
I don't know if speculation is lying, but
Well, let me just.
I'm not lying. I'm not lying. But I'm admitting, like, I was making stuff up. I was just guessing. And I have no idea if it's true or not, but that's totally not lying. And these are the guys who fucked me over out of money and out of my job at a law firm. But I'm not lying. They also fucked me out of that money that I was under contract with Fani too. And I had to give 30% of my cut to Nate Wade back. You know, I'm not mad that they cut me out of that and just kept wetting their beaks with all that money. That free government cheese. No, no, sir. No, sir. I ain't mad, boss.
Tell me where in this text it says you're speculating.
you didn't ask me if I was speculating or guessing.
I didn't ask you, but tell me if it says anywhere here. That
No,
this is speculation.
If this is the same one that you just showed me, it does not.
And you're welcome if you need to look at your text. Is there anywhere in here that indicates that you didn't have knowledge of
No.
this relationship?
Your Honor, I'm going to object the line of questioning, Your Honor, direct.
So there you go, guys. That's how it all turned out. Holy shit. Like, how does that work? Talking about all the things you lied about. I tell him all that was very, very specific, all that shit he talked about. Now he's like, I was just lying. I was just fooling about. He's like, let me smell that hair, girl. Let me pull a Joe Biden and go, you smell like white girl. Yeah, she's going hard on him. That's why he's like, I just wanted a white woman for woe. I just want a white woman. Why did it have to come to this? He's just looking at Nate Wade. He's like, dude, he's like, I just wanted to hump. He's like, I'm sorry, brother. He's like, brother, I failed you. Yes. What pogs? Oh. Yeah, it's like, did you lie? Maybe. So, yeah, it's his face radiates a lot of pain. Like, oh my god, I'm fucked. I have a feeling Fanny's gonna try to indict him for like everything now, and she'll be like, "Oh, and he got killed. He got killed." Yeah, we indicted him. We tried to arrest him. He died. I'm sorry. Yeah. My personal security detail went to go arrest him, and he happened to accidentally resist, and then he fell down a set of stairs 15 times. Sadly, he did not make it. Kaz is like, clap it, girl. Oh. DeMarie says he was speculating or his client told him or he observed. Yes. And that's the point. He's like, I was just making it up. It's like, well, you happen to magically make up everything that was correct. So, yes, Fanny's going to press conference say his black card is revoked. She's going to go to church and be like, throw it down. We no longer have that here. So, yeah, guys, that is somebody's in trouble right now. Someone's in trouble, a lot of trouble. And I don't know who, but there's 3 names, and maybe we'll find out soon. It sounds like on Friday there's going to be arguments about Friday. They're having arguments about the cell phone data, and the cell phone data is the data that the private investigator the Trump team hired used what's called CellHawk. It does all the phone kind of hoovering up if you get data from AT&T. So they sent out a subpoena. AT&T gave them all their stuff, and they run it through the same programs the police use. And I covered this. Oh God, what night did I cover it? I think it was last Friday. And yes, and it's just a lesson for you guys. When your motion to respond is in all caps, underlined, and you're screaming at the court, you've lost. You can't do that. So, yes, the district attorney's office tried to say, "Oh, the cell phone data is unreliable," and it's like you guys convict people all the time with it. So we now know that Nate Wade and Fanny would text at like 10 o'clock at night, and he'd come over and stay till like 3 or 4 in the morning. Like, they aren't sitting down working on puzzles at 4 in the morning. So, Jay Bet says Friday's going to be good. Yes, Friday is going to be very, very good, and we're going to cover that hearing. I know, like I said, Hannah Reid's going, but guys, this has got national importance, critical importance. And as I said before, I think once this case collapses, we then find out how interconnected everything else was. Because this was supposed to be the one Trump couldn't get out of no matter what. And this is going to collapse. And then I don't know if this is going to directly collapse what's in New York, or at the very least, I think it starts impeding and collapsing and eroding the federal cases. But it's just going to start the process of showing how bad it is. Yeah, Charlie's like he was burning some wood. Oh, I'm sure he was. Faraj Smile for $2 says shalom. Thank you. Stephen Cooper for $5 saying he's 2024's Rodney King. Yeah. Except now he's getting his ass beat by a black district attorney and her minions. And Bebop Rocksteady again for $4.99 says he's still sipping. He kept asking, "Can you repeat the question, Ashley?" He probably misses their convos. Yeah. Probably texted her afterwards, like, "Hey, girl, you up?" In the middle of the night, she's just like, "Get the fuck away from me." And he's like, "Oh, forever alone. Can't get the white women's." Oh, God. So, yes, Friday will be interesting. Forget what time it's at, but I'll let you guys know tomorrow. So we're probably going to talk about it a little more. Get ready for it. Oh, sorry, 211. Wow, damn. We've been having fun, chat. 1,000 guys here. Thank you very much for sticking around. Guys, give me a like if you appreciate it. Would do a lot. Help me fuck with YouTube's algorithm. Because they'll be like, damn, we gotta give him more like gotta get more views his way. Of course they won't do that, but we gotta try. Yeah, it's at 2 p.m. I think, but we'll see. Yes, Mr. Medicare wants to join. Yeah. That'd be great. That would be great. Darcy says he needs to leave ATL. Yeah, I'm sure he needs to watch. He needs to protect his neck. You need to protect your neck. I mean, but he can handle himself. So Medicare's probably hooked up to the machine for the night. Yeah. He's being recharged on the eternal throne. They're sacrificing the psychers for him right now. They have to sacrifice 1,000 lol cows a night for him. Oh. Dad saying, can't you guys get together and join stream? I don't know if I should watch you, Joe, or Nate. Well, watch whoever you want, but I'd like to say, you know, I am who I am. So I like to say, I like to say you get the best out of me, but you know, wherever you go is where you go. Do I think Sherrod Brown, and that's the thing, his name's not Sherrod. I hate it when they say that. It's gotta drive him crazy because he's probably like, eventually they're gonna say it. He's gonna scream at him, God damn it, I'm not black. No, his name's Sherrod Brown. He's probably gonna win again. I have a feeling. He gets a lot of the unions lick his balls, and they're like you said, he's probably gonna win this time around. I just have a guess. Just my guess. I mean, the guy always wins. Heck, he was one of my congressmen, I think, or one of my state reps. Somebody when I was growing up. He was in my area as a kid, so happens. Say, join Discord to see me admit RoboCop 2 is better than 3. I misspoke. RoboCop 3 is better than RoboCop 2. So watch out for Big Iron Boogie. Jesus. Boogie got his house vandalized. Did he get vandalized or did he just walk around and use it? I don't know. Fellow fat guy, I can make that joke. So, all right, guys. So Trump has been disqualified in Illinois. I know, shocker, it's happened again. I know, could you believe it? But it has. HM says there's RoboCop 3. Yeah. They've got the samurai robots, and then he's got the rocket pack and the jetpack, and he flies around, and he like shoots a missile out of his arm and all kinds of cool shit. And then the cops quit, which is really based, because then there's no police. And then the government hires in a bunch of like Pinkertons to become the police. And then everybody starts shooting at the cops and killing them. Like, what more do you want out of a movie? That's like the most base thing ever. And then RoboCop goes rogue and starts helping him kill the current police. Like, that's pretty bitching. Like, they're murdering police, and it's like, okay, it's cool. I don't know how you don't want that. I don't know how you want that. I mean, I really don't. You guys are like, you know, some of you guys have some shitty taste in movies. I can tell you that much. That's all I can say. And that's okay. I will bring you back. I care about you guys. You know, for some of you, you might need it. I'll be that father figure you never had. You know, I'll guide you with that firm hand. I can do it. I can do it for you. Oh, No, Camelot's here, man. Hey, Camelot, how you doing, man? Good to see you. Muzzy says Boogie's the fastest gun in the sector. What the fattest gun? No, Boogie's the fastest gun in a school zone. Oh. So. Which on my day, hey. A lot of people do. Like I said, don't call me daddy. There's only one person that's calling me daddy, and none of you guys are it. Steve says, we didn't even make a compilation of this. Do what you got to do. Restaurant Town says, wasn't helping the Native American girl. Yeah, I don't worry about that part. No movie's perfect. But RoboCop 2, like, here's the thing. Like, we're going to stop right now. RoboCop 2 is about RoboCop fighting the war on drugs. Do you support the war on drugs? Because that's RoboCop 2. They got to stop the evil brain robot from selling drugs to everybody. Can't let people get the dope. That's RoboCop 2. So if you want to be some bootlicking statist, RoboCop pulls out his big old police penis, and you're just like, I want that in my mouth. Then go watch RoboCop 2. Because that's the plot. That's the plot. He's a drug warrior. I don't want that. I'm surprised RoboCop didn't shoot a bunch of fucking dogs in the middle of the movie to really get the war on drugs vibe. If they had made RoboCop 2 now, that's what it had been. It'd been like him fighting the robot, and then like 20 minutes of him doing raids, killing dogs and shit. And then being like, qualified immunity, have a good one. So, and don't tell me I'm fucking wrong. You know I'm right. All fairness, the drug was nuke and it was fatal. It's okay. Just say you support the war on drugs. I get it. You can just say that. So, all right, guys. Well, it looks like enough people. Everybody's leaving, so we'll move on because you guys don't care. So, we got to move on. We got to move on here. I can hear a little bit of an echo, but I don't know where it's coming from. So we're gonna move on. Trump getting disqualified in Illinois. Like I said, once again, kind of a shocker. I know. Surprised they haven't tried to do it in California or somewhere yet, but they did it here. So where is it at? It's in our best friend in Illinois' best friend, Cook County. You guys don't know where that is? That's Chicago. So yeah, not a surprise. And it's really bad quality, I know, but we got to deal with it. So, and I say there's 38 pages. We're going to blow through this pretty quick, okay? So, there were oral arguments on February 16th, which is interesting because, we don't hear about any of this till it happens. And it's kind of interesting how this all gets on the down low. If I was Trump's people, I'd be screaming about this from the rooftops. Hey, these cocksuckers in Illinois are fucking with everything. But no, nobody says shit about it, which is so weird. They don't. But anyway, so they had a review which lasted. Oh, jeez, I hate it when you do this. Chrome, you're killing me, man. Whatever. So it lasted almost 4 hours. And they reviewed voluminous motions and briefs of the parties, which basically tells me they copied and pasted all the Colorado crap and reread it. The Electoral Board's common law record, which is 12 volumes of 6,300 pages. Oh, it's a lot of pages of record that were entered. I'm sure parts of the January 6th Commission were thrown in there as well. They had 267 pages of transcripts from the election board hearing officers, which that's a lot. It's not too much, but that sounds about right for about 4 hours of people talking and a court reporter sitting there pounding it out. That sounds about right. When you get to when you get to trials, you can expect about like a full day of trials, about 300 some pages, roughly. So that's about right. They had a pretty big old thing. So on January 30th, there was an appeal for judicial review. And this is where people filed 12 separate filings totaling over 6,000 pages. And the issue is the Board of Elections said, well, no, we're not removing them. People felt they were wrong, so they appealed this. And the court is taking a look at it. So the petitioners' objectors who are opposed to Trump, they complied with all their statutory requirements. So we get to the big stuff here. The disqualification clause. Once again, we have the same thing we talked about ad nauseum at this point. We have Article 2 about the electors, and the state can appoint its electors however it wants to. And the qualifications clause for president. We talk about that again. You know, it's a natural born person of the United States shall be eligible for president, and you have to be 35 years of age and been 14 years living inside the United States. That's kind of the last part of it nobody always talks about. But yes, if you were living abroad, you had to live back home for 14 years. Now, is that as big a deal nowadays? Well, no, but this is back when you went abroad, like Ben Franklin spent years in France during the war trying to turn up support for the war effort. So living abroad was an even bigger deal back then. We also talk about the oath of office. And this one's interesting because I haven't seen this argument before about the full faith and credit clause. And that's it's an Article 4, Section 1. But that this is probably how they're going to shoehorn in all the stuff from Colorado, that full faith and credit shall be given to judicial proceedings of every other state. That's not what it's meant for, but I bet that's what they're going to argue, that they accept it. So they talk about the Illinois Constitution. You know, the relevant parts are whether he's allowed to be there, and whether or not he is a valid candidate. So, and it talks about the certificate of nomination, or the nomination papers or petitions are in proper form. And they're going to say, you know, what's just like what they talked about in Colorado. They're claiming, well, we're looking at the forms and he didn't fill out the forms right because he lied on them, because he engaged in the insurrection. Ooh, spooky. I know, so scary. And they go on and on and on about this, the procedural history. So January 4th, Trump filed nomination papers and a statement of candidacy to appear on the ballot March 19th. And that's coming up. Obviously, it's the 29th today. Happy leap year day, everybody. And on that same day, people filed a petition to object and have him removed. And the state is disqualified from the office, and it's because of Section 3 of the 14th Amendment. Okay. For him to engage in insurrection, rebellion, blah, 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 blah. Yeah, because commies didn't want what's coming to them. I get that. Commies don't like that. That's okay. Commies don't generally like what's coming to them, but it's what they deserve that's more important in life. So January 19th, he filed a motion to dismiss. On that same day, the people seeking to remove Trump filed a motion to grant their objection petition. And here's where it gets interesting. And I mentioned this before, and I think it was a no-brainer to everybody as well. In lieu of live witnesses or presenting evidence out of what side the parties have presented in the Colorado District Court trial, so literally, they just took everything from Colorado and went, stamp Illinois court, good enough, and submitted it. That's the big thing Colorado was at the end of the day. It was the copy and paste. It was the copy pasta for all this. The parties agreed to an entry of a stipulated order regarding transcripts and exhibits from the Colorado action. Stipulated order set forth that because they filed a motion of judgment, they believe that with all that, they submitted everything and agreed to the evidence to be considered to the hearing officer by the Board of Elections, okay? So all the transcripts and all the exhibits admitted in Colorado or authentic, meaning everything that they talked about in Colorado, we're taking that whole record, like I said, just copy paste, bam, change the name on the homework, chat, so it doesn't look the same. Come on, try to fix it. Don't just put your name on it. They also argued all the objections stipulated in Colorado were here and they're preserved. That said, though, the hearing officer denied summary judgment in support of the objectors, the people opposed to Trump, because there are numerous disputed material facts in this case, as well as a wide disagreement on material constitutional interpretations. The logical issue here. Well, hey, it's not actually clear what all this means, so I'm not going to allow you to do this. Well, apparently that's unreasonable in Illinois. No, the Orange Man is bad. The Orange Man must be dealt with. Can't have the Orange Man running around. What does it mean Trump is off the ballot? Well, right now he's temporarily off the ballot in Illinois, but we'll get to that. We'll get to this real quick. So at the hearing, he said in the event the board decides not to follow his recommendations, he recommends that the board find the evidence presented at the hearing proves by preponderance of the evidence that Trump engaged in insurrection within the meaning of Section 3 and should have his name removed from the March ballot in Illinois. So which it's so they get to the board meeting and the board considered everything they determined, and they determined the objector's motion for summary judgment to denied, but Trump's motion to dismiss was granted in part. Okay, so the objection filed by the objectors was overruled based on the findings contained in the decision, saying there's too much constitutional issues we can't decide. So there's a lot of footnotes here. We'll get to the preamble, and this is where the judge is going to make their statement. Judge Tracy Porter. This case is riddled with issues of state and federal statutory and constitutional questions of interpretation. Well, it's not your job to interpret the Constitution. So that's where it should stop. Just like when people on Twitter, it's like, well, I'm not a lawyer, but it's like, that's where you should stop. It's like, I'm not a heart surgeon, but it's like, well, no, that's where you stop. There are just 7,000 pages of written material, and I'm sure she read them all. And 100 separate videos of all those poor heckin' police, man, on the Capitol. Oh, Lordy, so sad for them. And despite all the recommendations, this court cannot lose sight of the forest for the trees. This court, and it says this court must review the electoral board's decision based on its reporting of proceedings, common law record, and the evidence to determine if the decision should be upheld or reversed. So therefore, it talks about what's the standard they're going to do and what are the questions. So there's a couple questions here. They challenge the validity of the nomination papers because they're claiming he was never legally qualified because he engaged in insurrection. Okay. And because he engaged in insurrection, he can't be placed on the ballot. Yes, because that's what he really did. So the questions were, was it proper to dismiss under the grounds that lacked jurisdiction to conduct constitutional analysis? Did the objectors have met their burden by proving by a preponderance of the evidence that the respondent's candidate statement of candidacy is falsely sworn? And then ultimately, it's should the name be removed from the ballot as a candidate? So it talks about the standards of review here, and the standards of review of the elections board here. It is, they talk about ascertaining whether or not the courts against the manifest weight of the evidence here. What standard do they use? Why is this? I hate it when it moves around, but the standard review is going to be reviewed de novo. And that means that a clearly erroneous standard review as the appropriate standard to examine the board's decision. So unless it's clearly erroneous, they're going to leave it alone. The decision's deemed erroneous when the reviewing court is left with a definite and firm conviction a mistake has been committed. Not just, people could see it differently. So they talk about all this and they get to the biggest issue here. And they get to the issues here. So they break it down. That they had not met their burden proving by a preponderance that Trump had falsely sworn out a statement that he was legally qualified to hold the office. Okay. The second one is the issue of law about his oath to preserve and protect and defend the Constitution. But then who engages in insurrection, which is a conduct, disqualifies him and prevents his name from being placed on the primary ballot. Okay, well, once again, this is not any different than what we've seen everywhere else that this has been argued. And you're using the election code to qualify the candidacy for presidency because Section 3 of the 14th Amendment requires some interpretation before it can be applied to the respondent candidate. So they keep saying the city of Belvedere, and that's where it talks about election board concerning a question of law because the phrase wages, hours, and other conditions of employment was a term required interpretation. So they're not saying this is just like a case involving wages and hours of employment, but a case involving interpretation because it wasn't clear, like, what are other conditions of employment? So they examined the legally significant facts of the record, I'm sure, just that Orange Man was bad. And they determined that both state and statutory and federal constitutional legal interpretation are needed to determine the legal effects from the facts. So, because it's a mixed question of law and fact, the clearly erroneous standard review is appropriate standard to examine the electoral board's decision. And Belvedere wasn't even... Mr. Belvedere wasn't even American. Case closed. Chat, yes. That's it. Yes. God, I remember that show. Jeez, that was really going back in time. So, Pizza says SCOTUS will overturn Colorado and will be the end of this. Yes, it will. Yes, it will. But it's going to be interesting. It's interesting to see the levels of desperation that they will go to stop the Orange Man. Stop the Emperor of Mankind. They are desperate to stop him at this point. So they talk about the qualification of Section 3 of the 14th Amendment, and they talk about through the Illinois Constitution how this all is going to work. So the State Board of Elections has general supervision over the administration, registration, and election laws. Okay. It also includes determining qualifications for candidates for the office of the President of the United States. The Supreme Court has recognized that voting is the most fundamental significance under our constitutional structure. But you're not entitled to the right to vote. You have no right to vote under the Constitution. State can take away your right to vote and pick however they want to, and that's good enough. But if you have a vote, one man, one vote is the policy. But that doesn't mean you have to have a vote. So, they point out, though, that adding candidates are governed by both state and federal statutory and constitutional law. Qualification assure the candidates are well suited for the office they seek, and assure voters only qualified candidates under the law will be placed on the ballot when they vote. So when constitutional requirements are not met, voters are restricted from voting for whom they may wish. Yep. Term limits, age, natural born citizenship, residency qualifications. Now, in the INSA case, an assessment based on the Section 3 of the 14th Amendment are what can prohibit you. They talk about Article 2 in the qualifications clause. you know, you got to be natural born, at least 35 years of age, and a resident for 14 years. And the Electoral Board has determined prior cases involving natural born citizenship. And it's funny because they talk about Freeman v. Obama back in 2012, and then Jackson versus Obama in 2012, and then Graham v. Rubio. Somebody challenged Little Marco back in 2016. I'm surprised nobody challenged Edward Rafael Cruz, also known as the Zodiac Killer, but apparently he was left alone. So the Electoral Board canon has made determine decisions whether or not somebody follows the requirements of the qualifications clause. And it did so without interpreting the language, which is kind of a big deal. They're saying it, but they're also just saying, oh, that doesn't matter. We're going to interpret it anyway. But they're almost acknowledging we shouldn't be doing this, but they do go ahead and do it because they want to do it. The Supreme Court made it unequivocal the Electoral Board may not engage in statutory or constitutional interpretation, which I think is a very good ruling. We don't want you guys making shit up. That's our job. We're the judges. We make shit up. That's not your job. Don't steal our work. You can smell the union coming out of that. Don't steal my job. Oh, they talk about because of this precedent, it was deadlocked. It lacked jurisdiction to protect it lacked jurisdiction to interpret Section 3 of the 14th Amendment and cannot proceed to review the petition's qualification about objection. And they're like, yeah, we couldn't do anything about it. Therefore, this court, is whether it lacked the jurisdiction to conduct that analysis to determine whether Trump was even disqualified. So, once again, they cite the Electoral Board is prohibited from conducting constitutional analysis. And this is all Illinois Supreme Court stuff, not federal Supreme Court. So, big difference there. Big difference, guys. So, all in all, Illinois is gay. Pretty gay, yes. Pretty gay. Overall, it's Illinois. It's very French sounding. They keep talking about the natural born citizenship requirements, though, the residency and that the age have all been determined before. They don't require constitutional analysis. Yes. In the instant case, though, we find the findings legally relevant statutory and constitutional provisions would require the Electoral Board to do more than just verify the qualifications with objective evidence. The board would have to engage in an analysis and interpret the principles and qualifications. It's undisputed the board can't do this any more than it could declare a provision in the election code unconstitutional. And what the heck is going on here? I'll take a look at that later. So they're saying because the Electoral Board can't make that decision, we'll do it because I'm a judge. So I are judge. I are black robed. Why not? I are hating orange man. I can do it. So therefore, an interpretation is required to determine whether or not he's disqualified. And this is my job now. And the court finds this question of law is subject to contradictory and controversial interpretation, which is why the Anderson-Griswold decision from Colorado is pending, and a 4-3 decision is pending before the U.S. Supreme Court. The Colorado Supreme Court, however, is the only jurisdiction that has interpreted Section 3 of the 14th Amendment and has disqualified him. So, until the U.S. Supreme Court renders a decision in the Anderson-Griswold case now pending before it, reviewing courts are still under a constitutional obligation to apply and interpret the law and continue the momentum of the electoral process in the light of the primary elections. And that's from what was filed in the Trump case. So the judicial notice, they point, and this is the court taking judicial notice saying, I understand what courts have done somewhere else or something that's happened. So the court can take judicial notice of many things. It's facts that don't have an immediate bearing on your case. So, for example, will the court take judicial notice it's Tuesday? Yes. Will the court take judicial notice it's raining outside? Sure. Will the court take judicial notice that the murder is alleged to have occurred on May 24th and that was a Tuesday? Yes. That the temperature was 65 degrees outside. Well, there's no question about whether that becomes a key point of proving the murder occurred. The judge could say, yeah, we'll take judicial notice it was sunny outside that day or raining or whatever. A lot of facts the court can take judicial notice of. But they're talking about Anderson v. Griswold is not binding, but rather persuasive. Oh, I'm sure it's very persuasive to you guys. Thus, the court may consider the decision as precedent on issues under review by this court and may recognize or take consideration its holdings. And of course, what are they going to do? They're going to be like, oh yeah, let's take it all. She's going to stretch out her butthole and be like, just put it all in me. She's going to be like, yeah! As they put the entire court case in there. In Anderson, the Colorado Supreme Court is presented with the issue of whether Trump was allowed to appear on the ballot. The issue is, in the instant case, is similar, but not identical. By how much? What are we saying? Like, it's only 99% identical, not 100. So, yes, the only difference here is a district court decision, not the electoral boards. That's literally really the only difference. The basis for the objections in this case are the same. So it's basically the same damn thing. They just don't want to admit it. The Colorado court held Trump engaged in insurrection, but was not disqualified from the ballot. Remember that. And then it went up to the Supreme Court, and they said, well, actually, he did engage in insurrection, and he is disqualified from the ballot. So this court will proceed relying on the Colorado Supreme Court decision. Okay, well, you know where this is going now. Because it finds the majority's opinion well-articulated rationale and established in historical context and asserting the construction and meaning of legal principles, such as Section 3 of the 14th Amendment. Yeah. Okay. So we already know where this is going. Like, that's the shitty part of this. You already know where they're going with this, and they're going to fuck with you on this. M. Gabri's SF saying, holy shit, you're online? Yeah. That's how we do. Having a great day. It's time to pound it out. You got to keep going. Got to seize the day. You got to seize what's available to you. There's lands to be conquered, animals to be tamed, gold to be had in them hills. You have to go for it. You got to want to go get it. Just jumped off a Medicare stream. Like, wait. Like an old one? Because I don't think Jim's on tonight. I didn't know he was on. So, just Jenny for $10. Thank you, Jenny. Saying, hello, just loving the recent content. Well, thank you very much. I appreciate it. Patty Leather saying, I should have challenged Ralph to a Jello wrestling contest with strength. The loser has to listen in the Azov Battalion. Well, yeah, those are some. For listening to the Azov Battalion is like Nick Fuentes refereeing the match. The loser has to go and listen to the Azov Battalion. The winner has to go and listen to the Azov Battalion. The loser gets a cat boy of his choice. Oh boy, that's awful. But yes, Jenny, thank you for the chat. Oh, it's from 2 days ago. Okay. Was that with him and Worski? Because that was a pretty good stream. All right, so they talk about so basically they're copy and paste. Once again, chat, they're copy and pasting Colorado shit here, okay? Yeah, so they'll consider that, on appeal, the Supreme Court reviewed the district court's ruling, and Trump's disqualified from holding the office because he's a bad man. He engaged in insurrection. He killed everybody in Congress. Too bad he really didn't do that. I don't know if it's just me, but like next time he should just like while he's in the middle of a speech, just like fucking half a day. DC's just woof, just J-damned into it. J-damned out of existence. Donnie, I know you're listening. Take out your notebook or have one of your sisters like write that down. J-damn half a DC during election day. That'd be like be a good start. Be a good start, Donnie. So as interpretation of Section 3 of the 14th Amendment, this court looked at the Colorado Supreme Court's factual determinations, and it 100% fucking agreed with them. Through an exhaustive analysis of the factual and evidentiary records considered during a 5-day evidentiary trial. Yeah, some fucking trial. This court will not go through the exhaustive list of facts, but refers to the stipulated order. So it's not even they're like, I want to copy and paste your homework, but I'm not even going to fucking list it because I'm too fucking lazy. I'm just going to refer to it. So, yes, by clear and convincing evidence, the local court found Trump engaged in insurrection. Based on that evidence, the Colorado Supreme Court also concluded Trump engaged in insurrection. And then they also held that all the evidence that was admitted was valid, including the portions of the January 6th report, 15 sworn witness testimonies from the 5-day trial, and 96 exhibits, both written, visual, and auditory, are the same or almost the same. So the burden of proof applied by Colorado was a clear and convincing standard. So this is a higher standard than that employed by the Illinois Election Board under its rules of procedure, which only requires a preponderance of the relevant and admissible evidence. So preponderance is 51%, 51 to 49. Clear and convincing is a little higher. So where's that? Well, it's in between, preponderance and beyond a reasonable doubt. So it's not exactly clear, but it's like maybe like 60-some percent, like 2/3. The hearing officer correctly, you notice they point out the hearing officer correctly concluded all his recommendations and findings of the January 6th report. That the January 6th report is full of good heckin' boys and it satisfies the common law record. It satisfies the public records hearsay exception because it makes the orange man look bad. Even if the electoral board refused to make any factual findings about the event of January 6th, the evidence before the board cannot be ignored, and as such affirms the hearing officer's recommendations regarding the disqualification of Trump. By relying on those findings, it led to its conclusion that January 6th constituted an insurrection, and Trump engaged in it, and that Section 3 of the 14th Amendment applies and disqualifies from being certified for the Illinois ballot. And they met their burden of proof there. So this court adopts the determinations in their totality, which are just like the ones in Colorado. Notice they keep talking about that. It's like they're trying to admit, like, we're just fucking with you guys and literally just reusing the same play sheet over and over and over again, and you can't stop it until Clarence Thomas breaks it off in their asses. So, yes. And finds the record is would establish that Trump is disqualified to engage in insurrection and should not be placed on the heckin' ballot for president of the United States for the March general primary. This court also considers the Supreme Court Colorado's interpretation, seeking to hold office for second term, that even as a former president of the United States, he is covered under the Section 3 of the 14th Amendment. So just like was stated in Colorado, they talk about whether or not he is considered covered by that and whether or not his oath of office is covered by that. And they go to everything we talked about, and they all the same things. Literally, this is just a copy and paste of all the rationale from Colorado. And once again, they talk about because he said that he was good to go, he falsely said that he was allowed to be a candidate. And then he was duly sworn. And they talk about statement of candidacy that he's being duly sworn. He's legally qualified. Well, he's lying because he's a bad man and he committed insurrection. So, no, this is just more and more and more garbage And we get to the end, the conclusion that the electoral board's decision to keep Trump on the ballot as candidate is overruled. Okay. So it should have been granted, and Trump shall be removed from the March ballot. So their objection from summary judgment is granted and denying the motion to dismiss, saying that was wrong. That the Board of Elections was erroneous in finding that his papers and candidacy statement were valid, which I think is the argument that somebody in Illinois, particularly Cook County, could charge Trump with making false statements. I'm sure that's not going to happen. And that the decision to have Trump as the candidate on the Republican ticket is reversed. So he's removed from the ballot, and any votes cast for him to be suppressed. Now, the thing is, this order is stayed until March 1st, 2024, in anticipation of an appeal to the Illinois Appellate District or the Illinois Supreme Court. This order is further stayed if the United States Supreme Court enters a decision inconsistent with this order. Well, here's the thing. Is it going to be out by then? I don't know. Because let's say it's out by then. Let's say it doesn't come out by then. What happens? That's actually a really good question. That's actually a really fucking good question. What happens if this isn't done in time? I don't know the answer. I don't. All I can say is, uh-oh. If we get to like March 18th and he's not on there and it's like, uh-oh. Oh, they remove him anyway. Sure they do. I have a feeling they're going to remove him anyway, which I'm sure is not going to be a way to make sure people don't do anything rashly when you start fucking with the right to vote. I'm just saying. Nick Starro gifted 5 memberships. Thank you, Nick. Forgets one of those I know is going to appreciate it. Bebop and Rocksteady again, man. Man, working for Krang and Shredder, man. I mean, must be paying pretty good in the Technodrome. Saying, criminal, to your recollection, what's the hardest the Supreme Court has slapped down a lower court? Basically, knock off all your shit, and all you motherfuckers are on notice. I feel like that's needed here. I mean, there's times where that's happened, but I remember when I was working as assistant prosecutor, I came across a case where it was a neighboring county, and we were asked to help out, so I got to help do part of it. There had been this thing where this lady had appealed 5 separate times her one case. And it was because every time the judge kept fucking her sentence up and doing whatever he wanted. And finally, the court said, we're done. Her sentence is 6 years. We're not remanding this back down. We'll take care of it ourselves. We'll take care of all the filing. The lower court's no longer needed. And I was like, wow. They just told that judge to go fuck off. So you see that once in a while, but not very often. They try to have decorum and respect in the courts. You guys are liking the killdozer emojis. Yeah. You guys are members. You get to have access to the things like the Glock emoji and the White Claw emoji, the killdozer emoji, among other things. Oh, where's the doggo? I need a doggo. Oh, hold on. Here, click. Come on. Hi, buddy. Come here, Bubba. Hi. People want to see you. Hi. I know. Hello. Is there anything you want to talk about now? Huh? Is there anything you want to say? Ruff. Remember Waco? Ruff. Remember Ruby Ridge? Rough. I know. I know Ruby Ridge and Waco were very important things. I know. Thank you. Mwah. I love you too, buddy. Is there anything else you want to say? I know you talked about Building 7 before. Yes. Rough. Building 7 again. Rough. Anything else, huh, Bubba? Anything else you want to talk about? I already talked about the USS Liberty earlier, so. Rough. Fractional reserve banking is the devil. Rough. Ooh, we're getting to the fancy stuff now, huh? Yeah. Forgot to tell you guys, he does not like the Federal Reserve at all. You start talking about the Federal Reserve, he might try to bite you. He'll start growling and stuff, so. The only thing he hates more than the mailman. There you go, Bubba. So there you go. You guys got him. Yes, there's Benghazi as well. Yes, there's all kinds of stuff. Oh, he remembered the USS Liberty earlier today, so people already know about that. Is he a Lhasa Apso? So we did they do like the 23andMe thing for dogs. You know, he's like a Lhasa Apso. What is he? He's like Lhasa Apso, Shih Tzu, some kind of terrier, Chow Chow. He's like mainly Shih Tzu. I mean, you can tell because he's got the horn. But surprisingly, when we did the DNA test for the dog, he's not. He is 0.0% Ashkenazi Jew, unlike most people when they go take the test. So he's a good boy. He's the goodest of boys, you could say. Yeah, he's not 2% Ashkenazi. You don't have to worry about that. Nope, not any percent Native American, not any percent African. He's just dog. So is he down the Talmud? Maybe he will. I'll ask him next time if he will. So yeah, so that's going to be interesting because I have a feeling even if we get to the election, they're going to try to prevent from counting the votes for Trump in the primary. I mean, it's not a big deal now because we'll get to the election and this will be all sorted out, but it'll be interesting how this is going to shake out. So Thomas Fitzpatrick says never shuts up about the USS Liberty. Nor should you. Nor should you. Sam says, my dog shills for Israel. Well, you might want to fix that. No tunnels for him. Hey, that's okay. I'm sure he'll be okay. He can dig his own tunnels. He's a dog. He doesn't need your Abrahamic tunnels. He'll dig his own tunnels. Okay. Holy cow, Chad. It's 3 a.m. And I got stuff to do tomorrow. So we're going to stop. We're going to wrap this up. Thank you, everybody who's here tonight. I appreciate it. Oh, Just Jenny gifted 5 memberships. Thank you, Jenny. Rekieta says, I know is going to appreciate it. PA should be forced to fix their elections from 2020. Well, we're going to work what we got this time around. So, this child deserves more recognition. Thank you. I appreciate that. Someday, chat. Someday we'll get there. We just got to keep working at it. Got to keep doing our own thing, and it'll work out. So, all right, guys. Yeah, that is it for tonight. Tomorrow night, 9:30 Eastern time. Wow, I butchered that all up. Wow, what the fuck did I just do there? I hella colored that. So, guys, yeah, tomorrow night, 9:30 Eastern time will be the Thursday live show. We got to talk about, including, well, whatever melts down in the meantime. But yeah, we've got the Hannah Reid trial. I know the Michelle Trachona, she helped him chop up her boyfriend's wife at the time. Get rid of that. She is up for, we might find out what happens to her. It's a bunch of stuff we'll be able to talk about. So it'll be a lot of fun. And we do it every Thursday night at 9:30, guys. So please be there. It's a great time. We're everywhere on Thursday night. We're on Rumble, Twitch, Kick, Twitter, Facebook, YouTube. We're on locals. I mean, damn near everywhere, guys. So I appreciate you guys all being here. Thank you for all the chats. And Rumble, I did get to see this. We did have a Rumble rant, and I almost forgot about it. Swizgar over in Rumble, he did say, "Have you recovered from all the dunks Ralph landed on you?" Thank you. Thank you for that. Oh. Oh, gosh. You guys are funny over there. So. Yeah. Oh, wow. So, like, it's seriously, it like freezes out half the Rumble chat. I can't see anything. So, it doesn't show like anything else after the super chat. So, yeah, Real Patriots Party, Neurodivergent one of many. I know you guys are over there. Have a great night over at Rumble. And everybody here, have a nice night as well, guys. Take care. And I will see you guys tomorrow. Oh, we got another. Jonathan Doiger is saying for $9.99, Jocko had the Survivors of Liberty in his podcast. Oh, Jocko's a lot more fucking base than I thought he was. That's a lot more base than I thought he was. Like, it's like, okay, get up at 4, tell people what's up, and do your thing. It's like, okay, that's pretty base though. That's pretty based. I'm gonna have to listen to that. Be very interesting. So, yeah, guys, that is it for tonight, and I will see you guys tomorrow. So have a great night, and well, actually, we'll do something during the day. I'm not sure what we'll do. We'll probably catch up on Hannah Reid. So I got to do stuff in the morning. I got some stuff to take care of, and then I'll be back. So until then, guys, take care. And yeah, I'm trying to catch what you guys are talking about here. So good night, everybody. Take care. Bye.